Tonight's workshop is entitled A Smorgasbord of Legal Stuff for HOA Governance. I would like to introduce our speakers. Melissa Garcia is a shareholder at Altitude Community Law, PC, and is the head of both the transactional and business development departments. With almost 25 years of experience, she loves this community association law arena because it allows her to work with a variety of people to develop real solutions to challenging association problems. She is a frequent teacher at both local and national levels on all issues facing associations. She presents an annual series of HOA workshops for several cities in Colorado, regularly teaches for the Community Association Institute, and is an established presenter for HOAleader.com. She has received numerous awards, and her experiences have honed her people skills, so she understands different approaches and communication styles, making her especially effective in HOA law. Amanda Ashley began her career as a criminal defense attorney. She advocated for persons with HIV and AIDS at Vivint Health, a nonprofit organization where she practiced in employment discrimination, Social Security, disability benefits, bankruptcy, and estate planning. She enjoys debtor-side bankruptcy law. When she moved back to Colorado, she started working to assist community associations. Her well-rounded legal background allows her to address her clients' needs. She has skills in the courtroom and boardroom. She is licensed in Colorado and Wisconsin, District of Colorado, and the Eastern and Western Districts of Wisconsin. She enjoys spending time with her family and reading a good book in her spare time. Please join me in giving a warm welcome to our presenter.
Hi everyone, how are you tonight?
Good.
Are we missing any sports, TV? What are we missing tonight? Anything? This is better. This is better. All right, so thank you, Betsy, for the intro. I know you guys already signed in, but I have another sign sheet for us. If you don't mind, I'm gonna have Amanda take it to the back row. If you could just circulate it up all the way to the front, that'd be really fantastic. We have a great program for you tonight. A smorgasbord of legal stuff for HOA governance. And what we're really gonna be doing is an overview of the statutes, the Colorado statutes that address HOA governance and that control your associations, because a lot of you have governing documents that might be kind of old and they're not compliant with Colorado laws. We're going to go, how many of you have governing documents that are over 10 years old? Okay, well this applies, a lot of this applies to you, because we're going to go over the statutes, both HOA and the Nonprofit Act. Then we're going to go over some federal law that is applicable to HOAs. There's a lot of other laws out there, but we're going to talk about the ones that are mainly impact associations. And then we're going to talk about governing documents and how those work to help associations and govern them and all of that good stuff. Oh, you put up that slide. You tell us what that means. And who is that?
It's a good one, isn't it?
Who is that guy? Does anybody know? Yeah, well, no, not his dad.
His uncle.
Uncle Ben.
Yes.
Who's the
I
actor?
don't know who the actor is.
It's a little Christopher Walken-esque.
Yeah.
So normally you'll hear with great power comes great responsibility, but sometimes it comes with a lot of other issues, such as unclear responsibility, or what the heck am I doing now, right? And no accountability.
So is it Robert Conrad?
No.
What's that guy's name? I can't remember his name now. Oh well, you'll remember it at the end of the class. If you can remember, you get this. All right. So we have a lot to go over, but I really like to have this be a interactive. We like questions. I mean, you can certainly hold them till the end if you want to, but we try to take questions as we go through it, so that if you are, writing down notes, and if you didn't come up here, we have some great little giveaways as to-do pads and everything. But when you're writing down notes and you're trying to think about your questions as they pertain to what we're talking about, it's a great time to raise your hand, and we'll try to answer your questions as we go through. This is scheduled from 5:30 to 8 p.m., so that's 2.5 hours. We won't take 2.5 hours. We'll probably take 5, if that's okay. No, we'll send you home. No breaks at all, no nothing. But we really do have a lot to go over tonight, but I really encourage you to raise your hand. And if you have questions that pertain to what we're talking about, we will try to answer them, okay? Alrighty, let's get started. So first we're gonna talk about Colorado statutes. Colorado law, the legislature loves HOAs for some reason. They keep focusing on them every single year. There's changes in the law. We can do a class, and we often do a class, just on the legal changes for that year. There have been a couple for this year. There was some pretty major ones last year. If you've never been on our website, get on our website because we have this thing called the legislative tracker on the very top, a drop-down menu. Our website's at the very end of the presentation. And it tracks all the laws that were passed over the last, I think we have 5 years up. So definitely take a look at that if you want to know what's affecting your association. But they're important because they often supersede what's in your governing documents. So if you have old governing documents, then you need to know what the law is, or you might be doing this great job of following documents that are non-compliant with Colorado law. So you really need to know that. So the first law we're going to talk about is the Colorado Common Interest Ownership Act, also known as Kiowa. Who has ever looked at Kiowa here? Well, actually, let me give you a show of hands. Who has been on the board for less than a year? Anybody? Okay. Lock the doors. They can't quit tonight, okay? Regardless of what we talk about. Okay. Anybody been on the board for more than 5 years? Okay. All right. Well, if you've been on the board for more than 5 years, I hope you've seen Kiowa. This statute governs almost all associations in Colorado. It is, I don't know, like 40 pages long, maybe longer, and it's really dense, and there's a lot of legalese, so if you suffer from insomnia, just open it up, and you'll fall asleep right away. But it's a big statute, and every year there seems to be another revision to that statute. So on our website is Kiowa, so on the very front page, up to date, through this year's legislative changes. So make sure you download it if you don't have it. So Kiowa provides a framework for associations. It discusses how to create them, how to operate them, how to transition them from developer control, how to terminate covenants. So it covers everything. But the one main thing initially you should know is what kind of community are you? A pre-Kiowa or a post-Kiowa community. So as you'll see here, and this is important because if you are a pre-Kiowa community, then only some of Kiowa is applicable to you. And so who here is in an association that was created prior to July 1st, 1992? No? Okay, just a few of you. So for those of you who are in pre-Kiowa associations, I want you to, I did write down, 38-33.3-117. Look that up in Kiowa. That has the list of all provisions of Kiowa that are applicable to you. So for pre-Kiowa associations, that part of Kiowa, right at the end there, is the list of provisions that are applicable to pre-Kiowa associations. Everyone else is post-Kiowa, so you created on or after July 1st, 1992. And when I say created, I mean when was your declaration, aka CC&Rs or covenants, when was that recorded with the clerk and recorder's office? That's the date that you look at to determine whether you're a pre or post Kiowa community. So it's really important to know which one you are so you know what you're subject to, but you should also know that there's been talk amongst the legislation, this has come up a couple of times, of collapsing the two so that all of Kiowa is going to be applicable to everyone. Now, another question that comes up sometimes, and I don't think they're talking about this in your amendment about if you amended pre-Kiowa, you're talking about pre-Kiowa. So another thing that comes up sometimes is when pre-Kiowa associations are amended and rewriting their documents today, does that mean they become a post-Kiowa association? That question comes up quite a bit. The answer is no. You're still a pre-Kiowa association, so you don't have to worry that if you're gonna rewrite your documents today, then you're all of a sudden gonna become a post-Kiowa community. You're not, you're still pre, okay? All right, so Kiowa also has some exceptions to who is actually subject to the statute. We're not gonna go into the details of this, but if you look at the side, you'll see little numbers there, 3-121, 3-116. Those are all the references to Kiowa if you want to look these provisions up. Because right here is a slide that talks about exceptions to communities who would otherwise be considered a Kiowa community, but they might fall under one of these exceptions. The most popular one I see up here is that second one, the small and limited expense communities. If you fit within the provisions of that part of Kiowa, then you are only subject to a few provisions in Kiowa. And the things I can think about are if your assessments for the entire year for one lot don't exceed maybe, I think it's $400 or $425, and you also have to meet certain other criteria. So if you're wondering if you are part of one of those exceptions, you can take a look at these 4 sections of Kiowa and see if you fall within the factors. Okay? All right.
Well, those are the numbers over there.
Yes, at the very end are the numbers.
Okay.
So you just stick in that first, when you get onto our website, stick in 38-33 dot, and then it's those 4 numbers.
Now, when you say your website, tell me what that is.
It's altitude.law.
Okay.
www.altitude.law. And it's also at the very last slide as well.
You'll see on the first page of the website, you'll have the links to the nonprofit code and to Kiowa specifically, so you can open it and then search what you have open.
And also, as we're going through this, because Kiowa is split into 2 different pre and post Kiowa, as I'm going through the provisions, I'm going to tell you whether it's applicable to all associations or just post. And it's also going to say it on the slide as well. So you know, if you're a pre-Kiowa community, either I have to follow that or not, but if everybody here who's part of a post-Kiowa community, everything I'm going to talk about under Kiowa is applicable to you. Yes?
And just to be clear, when you're talking about exceptions,
Yep.
if you meet an exception,
If you meet,
Kiowa doesn't apply at all.
Kiowa applies, there's like 3 provisions of Kiowa that apply. And some of them, I think it's the commercial one, where is it? 100% non-residential. On that one, I think none of Kiowa applies. So it depends on which exception that you're looking at. Okay, let's move on. Okay, so let's talk about provisions that are contrary to public policy. So in the beginning of Kiowa, because there's 4 sections, section 1, 2, 3, and 4. The first one contains all these provisions that are contrary to public policy. We're going to talk about each one. Now, we're not talking about all of Kiowa in this presentation. I just picked the provisions that were really pertinent, which I see a lot with associations to discuss. But this first one, those 3 sections up there, those deal with things like flags, signs, emergency vehicles, EV charging stations. I'm going to talk a little bit about each one of them. Well, not each one of them, but some of them, because you should really know, particularly if you have a community that is, for example, EV charging, electric vehicles. I don't know if anybody's starting to deal with that, and anybody here, but electric vehicles, there is a part of Kiowa that essentially says, under the EV charging station section, that you cannot ban EV charging stations from being installed on the unit or the limited common element, which is common element that's exclusive to a unit owner, or the general common element. So you can't prohibit somebody from installing them, but the statute goes into provisions that allow you to make them enter into requirements about who's going to pay for it, who's going to pay for the energy, who's going to pay for the maintenance, who's going to insure it. All of that is covered in that statute. But that's going to override whatever's in your governing documents, which might prohibit installation or allowing owners to install EV charging stations. I know that Amanda's going to talk about, slow down for a second. Amanda's gonna talk about solar panels later, so she's gonna go into detail about that. Energy efficiency measures. For those of you who didn't know this, things like evaporative coolers, retractable clotheslines, awnings, and other things cannot be banned in an association, but you can still regulate them in terms of aesthetics. Yes?
What about, radon?
Radon mitigation systems?
Yeah, whether
Yes.
it's on the outside or has to be in the garage.
Sure. So radon mitigation systems are not stated in Kiowa. However, so on the exterior, are you in a townhome community or are you in a single family
Patio home.
Patio home. So oftentimes, what the governing documents say is you can't install anything on the outside, right, of the lot or the unit without getting approval from the association. That would still apply to the radon mitigation. However, I would not, as an association, ban or prohibit installation of radon mitigation because you want to allow them to have it. Even though it's not in Kiowa, it should be, but it's just not in there. So I would still allow it, but you can regulate it based on aesthetics, location, placement, and all that. Yes?
What about the high efficiency furnaces that, are like 93% efficient, but have to be vented outside, and so you've got these huge
Same thing,
pipes
so
coming
the
out?
question is high efficiency furnaces, that's not dealt with in the statute, and if you are interested in the statute, look, I think it's 106.5, it's gonna list, there's maybe 10 things that are considered energy efficiency measures. That's not one of them, but again, often associations do have the right to regulate modifications to the unit, usually the exterior. Okay, so signs and flag, one more, yes.
So do these,
We're only on slide 2, people. Come on, go ahead.
So do these have to go, some of them have to go in the declarations, or are they all just gonna be in rules and regs?
Good question. The question was, do these regulations have to be in the declaration? No, they don't have to be in the declaration. Because the ones that are listed up here, the statute gives you authority to adopt rules and regulations. So even if you don't have anything that says signs or flags in your declaration, and we're going to talk about the declaration, you can still adopt rules and regs. If you do have something in your declaration that addresses it, then you've got to look at two things. You've got to look at whatever your rules and regs do. They can clarify it, but they can't be inconsistent to the statute. So I want to talk really quickly about signs and flags because that was changed 2 or 3 years ago. And it used to say, the statute used to say that you have to allow political signs. You have to allow US flags, military flags. That's all gone now. Now, this is in 2021, I think? 2021, the association can no longer regulate or ban signs based on content. You can still adopt content neutral regulations. So what does that mean? Somebody wants to put up a sign that says, I hate my HOA, or I hate my management company, or whatever, they can do it based on just the language. You can't say what they can or cannot say on the sign. However, you can regulate size, location, whether it's professionally written, how many. So those are content neutral. There's one exception, and that's commercial signs. So if you have a for sale sign, for rent sign, a builder sign, a landscaper sign, you can still ban those, you can still regulate those how you want, but when it comes to non-commercial signs, you are limited to content neutral regulations, and if you don't have any, you better adopt some, because then if you don't adopt any rules and regulations over signs on your, and there's a scope of where they can put them. They can't put them on general common elements, for example. And depending on the community, they might not be able to even put them on the patio. So there are some limitations. But if you don't adopt any regulations at all, theoretically they can put up 10 signs, right there. So you want to make sure that you adopt a rule and regulation for content neutral. Yes?
Yeah, when I talked to the city, this was a while ago, especially during the election time, they had in the material, maybe it's changed, I don't know, the size and how many signs could be put up in a yard and all that. That hasn't changed, has it?
I don't know what the city has done,
They
because
had
all the
like 12
cities are
signs,
different.
and they had limits on the side and whether attached to a wall or
Yes,
fence
yes.
and all that.
So you can be, the city, whatever the city adopts, You can be stricter than that in your regulations, so you can be stricter than the city, but you can't violate the city regs. So if the city says,
overrides whatever.
Yeah, you can just be stricter. If the city says, up to 6 signs, you can say 2 signs. If the city says 6 chickens are allowed, you can in your covenant say no chickens allowed. So you can be stricter. All right, same thing with flags really quickly. You cannot ban or regulate flags based on content. You can adopt content neutral. Yes?
You said it can never be in the common element when we were.
The general common elements. So general common elements are common elements that are open to everybody.
Right.
So the statute doesn't address that. It says it has to be in the unit boundaries and signs have to be in the window or inside the unit. Flags have to be inside the unit, window, or balcony.
So we can't allow residents to put.
No, you can allow, it's just that you can't ban or prohibit
Those areas.
those areas,
I-
yes. Okay?
Okay,
All right, sure. So one more I want to talk about, xeriscape. This just happened this year. So xeriscape laws have been around for several years. You can't prohibit or ban xeriscaping. But this changed this year to split the types of community and how the legislation is going to affect each community. It essentially took single-family home detached communities, so your regular single-family homes. It carved that out and placed a new law that's applicable to the detached single-family home communities. And then the other ones, the townhomes, the condos, the attached single-family home and the condos, the old law is applicable to them. And the old law essentially says you can't ban or prohibit xeriscaping, and you can't ban artificial turf from being in the backyard. So the new law, the interesting thing about the new law is that it requires associations to do something now. Well, for one thing, it requires single-family home detached communities to adopt at least 3 pre-approved water-wise landscaping plans, so that homeowners who want to install water-wise landscaping plans can just look at those and not have to go through the entire process of getting them approved. So you are actually required to adopt 3. If you haven't adopted them, the law came into effect August 9th. So if you get on our website and you look up xeriscaping, you'll see links and you'll see a great article by this lady right here about this whole law that kind of explains everything and gives you some links of certain water-wise landscaping plans that you can adopt. But if you haven't adopted them yet, you should. The second piece, and there's more to that statute, but the second piece is for single-family home detached communities, you must allow vegetable gardens in the front, side, or backyard. But you can still regulate on aesthetics. You just can't regulate the type of vegetable. But is a tomato a vegetable or a fruit? I don't know. What do you guys think? What's marijuana? Is that a vegetable? Because the statute says any pollinating plants are considered vegetables. So there's a lot of questions about that, yeah.
Can you regulate the height of the plants?
Maybe. So you're trying to look at aesthetics. So you try to get it around aesthetics because that's what the statute says. So we'll see how it plays out. We have some suggestions in our article, but there's nothing, no clarification at this point.
So my board is not saying you can't plant corn, they're just saying nothing
Above a certain amount, yeah. I mean, we'll see. We'll use you guys as a test case. We'll get you on the news. No. Yeah. Yeah, thanks for coming. Yes.
Can you regulate aesthetics of what's inside the balcony area?
So the statute discusses front yard, and I can argue that the patio is not the front yard because it's concrete, but your documents probably allow you to. So look at your governing documents. It's just the statute. So that's just 2 pieces of that new statute. You definitely need to take a look at it. Again, get on our website. Okay, so religious symbols has always been daycares, emergency vehicles. That's been the law for several years. But these are just examples of things that override your governing documents. And so you need to know them so you know that you're following them correctly. All right, so the next piece I want to talk about is statute of limitations. 3-123, again, you look at 38-33.3-123. This is a statute of limitations on enforcing construction violations. So somebody puts up a fence that wasn't approved, or puts up a patio that was not approved, or it was approved and then they built something that wasn't according to the approved plan. Whatever, if it's a construction violation, then this applies, and essentially requires you, as associations, as boards, to take action within 1 year of when you knew or should have known about that violation. 1 year, you have to take action. That means you have to sue them. Not write a letter, but sue them 1 year from when that fence went up, or when you knew about that violation if it wasn't obvious. Okay, so that's really important for construction violations. Yes?
Are sheds permanent structures?
What do you guys think? Are sheds permanent structures? No. Maybe it depends on the shed. It's permanent, you know?
Cement.
If it has cement, if it's a she shed, of course, you can. But if it's permanent, here's another example. Window mounted AC units. I'd argue that that doesn't apply because you can take it down. So, pergola. I mean, if it's something that you don't take away with you, I'd say it's a permanent structure that this applies. Okay? Okay, so the other one, just this other section really has to do with, they changed the law in terms of collection remedies and enforcement remedies and the attorney's fees that are applicable. It used to just say attorney's fees are applicable. Now they switched it to say for collection, you can require reimbursement of attorney's fees, and there's some question about that under the new law, but they changed covenant enforcement to say you can seek reimbursement, which is very different from requiring. So they treat the two differently, and that really has to do with the attorney's fees that you have to pay in order to enforce or collect remedies. And if you want to look at some of the specifics, just take a look at those two statutes. But that first one is really important about the construction violation, because if you don't take action, you can't make them remove it 2 years after. And if they can show that you've known about it for a year, and if they have an attorney that's defending them, they're going to say, sorry, you waived your right. Because courts want you to not sit on your hands for those kinds of violations. Okay, so creating the association, just so you know, for associations in Colorado, for common interest communities, a declaration has to be recorded, and as well as a plat or a condo map, depending on what kind of community you have. Typically, they're recorded together. The reason why I raised this one is because we've seen just recently, and it's in the north, a lot of north associations, where the developer, for whatever reason, would record the declaration, but failed to record the plat, or the other way around. And so there was an argument that, hey, my lot is not subject to your covenants. So if you have covenants and maps that are, older, maybe over 20 or 30 years old, then make sure that they are recorded with the clerk and recorder's office. Yes?
What happens if the recorded documents got destroyed in a fire from City Hall?
Oh my gosh, did that happen? So the recorded documents really should be online, but do you have any knowledge or any documents that would establish it? Because usually you can look at one or the other. Were both the covenants and the map destroyed, or just one or the other? Or do you,
the original maps are not.
Okay, that's better, because the covenants themselves will usually put the property description in them as well. So barring that though, if you're really wondering, hey, I'm not even subject to any of these, come talk to me after the class. Because it really depends on a lot of facts. But they should be online. So it should be in the cloud somewhere, no? Okay. Not your city, right? Okay. Yes.
When you say recorded, you're talking about with the county, correct?
Yes, the county clerk and
Not
recorder's
state,
office. The county clerk and recorder's office.
And it should have a
Weld
stamp
County.
at the top that'll say recorded in
Whatever
such and
county.
such county. It has a number, it has the date it was recorded.
Okay, so limited common elements. Anyone here in a condo community? Any chance, a few of you? Okay, so I just wanted to put this up here, and you'll see post-Kiowa community. Also for post-Kiowa, that means it's only applicable to post-Kiowa. So any of you pre-Kiowas, you don't have to deal with this one. But for post-Kiowa communities, if you have limited common elements, and those are common elements that are exclusively used by one or more parties. So garages or balconies or something like that. You can swap them with somebody else. Let's say you don't like your parking space, but you want to redesignate it with somebody else's LCE parking space. You can do so, but you have to do it according to the statute, which requires an amendment and it requires you to go through some process. Same with the association designating limited common elements. Let's say all your parking spaces are open to everyone and the association wants to assign them to particular units. The statute allows a process for it. Again, it's going to be an amendment, but it is allowed. Okay, public disclosures. This is something that none of my associations seem to know about. I hope you know about this. It's been law for over 10 years. And what it requires is for associations, all of them, all CICs, CIC just means common interest community. All associations have to follow this. Every year, well, first of all, the newer associations, right after they develop, they transition from the developer's control, they have to disclose this laundry list of items that's in that statute. But for all the rest of you who have already transitioned into owner control, there is a list of items that is in that statute. Again, I'm not going to go through every single one of them tonight, but that you have to disclose to the members every single year. And what I mean by disclosures is one of these three methods here. On your website, you have to have these records and these documents. The ones I can think of off the top of my head are a copy of your governing documents. It even says a copy of your, or reference to your insurance policies. These are post-Kyle communities. It'll say who's your management company, if you have one. So it's probably about 15 to 20 things that you're supposed to disclose every year. It's only hard work on the front end because you put everything on your website. If you have one, that's the first easiest method. And then every year you just have to say, our annual disclosures are on the website. And you send a little note to all your homeowners with your annual meeting notice, for example, or with a newsletter saying, all disclosures are on our website. The other two are, you can have a binder with all this information at your management company's office. And if you don't have a management company, then at the address that's listed as your principal place of business. So that might be a board room. Or you can mail or personally deliver the information, which I don't know why you'd want to do that. Somebody had a hand up, yes?
Is that pre and post Kiowa?
Yes, it is. Yes.
So if the board says, well, we know that the majority of our homeowners don't have computers, don't read the minutes, so why should we?
Why should we do it? Because the statute says you have to do it.
Thank you so
yes,
much.
Yes, because the statute. And not that there's a Kiowa cop out there that's going to fine you or anything, but here's where I see it become an issue. Is let's say somebody's really upset about your decision and sues the association. They're going to look at every little thing that you do wrong. Their attorney is going to say, did they comply with all of these things? And they're going to go through all the technical requirements because what they're doing is they're trying to make an example of you as a board member and trying to build a case of breach of fiduciary duty. One technical violation, courts aren't going to care about that. I mean, they don't want to second guess the decision of a volunteer board that's not being paid for the decisions, right? But a lot of them together, that could lead and make you liable for breach of fiduciary duty. That's why you want to comply. Yeah.
What constitutes disclosure? Is having things posted on the website?
That's one of them. That's one method right there. The first one on the first bullet point. That's the easiest one. And then you send around an email saying our disclosures are on the website. Yeah.
If you have a binder on premises, do you have to have a website?
No, but on premises means that whatever is designated as a principal office of the association. Who knows where their principal office is? You don't even know what I'm talking about? Okay, because if you get on the Colorado Secretary of State's website, there's a place where you can search up your association name, and once you find your association, the front page is going to say who's listed as your principal place of, or which address is listed as your principal place of business. Now for management companies, those that are managed, that's usually their management company. But if you don't have a management company, then it should be a board member, and if a board member resigned and it's somebody from 10 years ago, you better get that updated. Yeah,
So
one
in
more
a-
and then I'm gonna keep going.
In an ideal world, you have owners who purchased a patio home, a townhome, a condominium, who understand that this exists. Whose responsibility is it to advise a new owner that there are declarations, there are bylaws and all this? It seems
The
to get
question is,
lost.
whose responsibility is it to advise new owners of all these documents? Nobody's, it's the owners. When they buy into the community, they need to read their own documents. There's nothing that requires the management company to do that, nothing that requires the board to do that. Individual owners need to read their own documents.
It should be disclosed when they.
Well,
at time that
the
they
real
file.
estate people
But
have
they
to
don't.
The real estate.
But there's nothing that requires you as an association to do that. Okay. You should, and Amanda's gonna talk a little bit about that when it comes to the covenants. Okay, let's move on. So next, required policies. So the required policies, Amanda's gonna go over in her part of the presentation, but these are essentially 9 courses of action called policies that the legislature has said boards have to adopt. And if you want to see the list of 9, it's in that section. And again, Amanda will go over that section. Owner education, all CICs, just like the policies. This is something that a lot of associations don't know either. And that is every single year, you are supposed to provide education to your owners about HOA governance. Things like rights and responsibilities of the association, board member duties and obligation. There's various topics that you can use, and it's listed in that statute. Now, how you perform that is up to you. You can, for example, have your attorney come to the annual meeting and present for 20 minutes, half an hour on a topic. You can get an HOA governance article and circulate it amongst the community. That will satisfy that. If you are going to circulate an article, make sure that in the article itself, at the beginning or at the end, you put something that says, this is done for the purpose of complying with this year's annual education requirement. So it's paper trail that you did. Okay? Okay, so declaration amendments, and Amanda's gonna go over that, but this section 3-217 describes the amendment requirements in the process for amending governing documents, amending the declaration. And some parts of that provisions, of that section are applicable to pre and some post, but we'll look at the amendment section later on in the program. So board powers. If you are wondering whether or not the board has authority to do something, this is what you can look at, 3-302. And there's probably about 20 items that are default powers of the board. So even if it doesn't say something in your documents, you have the right to do it. So for example, it says the boards have the right to adopt rules and regulations. The board has the right to collect assessments. The board has the right to do all these things. Now, the thing you have to be careful about, though, is some of those provisions will say the board has the right to do X unless your governing documents say otherwise. So when you're going through that, for example, if it says the board has the right to, here's a perfect example. The board has the right to borrow money and secure that with an assignment of income if it's stated in your declaration. That's a real power. So what that means is if you're trying to enter into a loan and you're a post-Kiowa community and the bank is saying, we want to secure that loan with assignment of your assessments, you better have that authority in your declaration because Kiowa says so. Kiowa says you must have that language. So when you're going through that laundry list, make sure you look at the exceptions and the caveats in each item because that might change whether you really do have authority to do it or not. So another thing that a lot of boards don't know about is 3-303, 1B, and this is applicable to all associations. What this provision discusses is if a particular board member goes off and gets an opinion, for example, from the attorney, What this provision says is that opinion is available to all other board members. So if you're getting professional information, advice, and all that as an individual board member, it's available to everyone else. I'll give you an example that comes up quite a bit. Let's say you have a warring board, okay? You have 2 people that hate the other 3 people, and they want to remove the other board members. They call us. They say, please give us an opinion on how to remove these other board members. We always say, sure, but they have the right to see this opinion too, because of that statute. So just be careful. So you know what you get, it has to be disclosed to the other board members. And amendment of bylaws, Amanda will talk about that in her section. All right, the budget veto process. So, who here, raise your hand again if you're a post-Kiowa community created July 1st, 1992 and forward? I think it's most of you. Okay. So this whole section of Kiowa requires all post-Kiowa associations to adopt the budget in this manner, which is essentially, even if your documents, even if your declaration said the board, and right now I'm just talking about post-Kiowa, even if your declaration says, hey board, you have the right to adopt whatever budget you want, you adopt it, you're done. Even if it says that, the Kiowa statute is going to supersede that. And it's essentially going to say that you have to adopt a budget as a board and send a summary of that budget to all owners within your community, and then you have to hold a meeting at which that budget is going to be considered, and then offer it to the homeowners for an opportunity to veto. Very different from approval. Veto means they have to show up and veto it. And what the statute says is, as long as a majority or anything higher, stated in the covenants, as long as a majority or anything higher of the entire community doesn't show up in person or by proxy to veto it, it's deemed approved. So it's a lot easier than approval. Because let's say you have 200 people in your community, 101 have to show up at the meeting in person or by proxy in order to veto it, or it's deemed approved automatically. And the reason why this came about is because the statute, the legislature realized that it's very difficult to get people to show up at annual meetings. So a lot of boards weren't able to adopt budgets, not because of objection, but because of apathy. So they came up with this veto requirement, which is a two-way process, two-way street. You have to show up if you care about the budget and be that check on the board. So that's how the budget process works for post-Kiowa. The statute was changed several years ago to also apply it to pre-Kiowa, but there's one exception. And that exception, I think I have it up here, yep. For pre-Kiowa associations, if you have something that says the board can adopt the budget and that's it, then you might still be able to use that, because if, as a pre-Kiowa association, if your declaration has a cap on how much the board can increase those assessments, over which that cap the owners have to approve it, so you already have this built-in mechanism of owner approval for any increase over a certain amount or percentage, then you don't have to do the veto process. You just follow your documents. So your documents might say something like, the board can increase the budget up to 10% over last year's, but if they want to go over 10%, then they have to get owner approval. So if you are one of those pre-Kiowas that has that exception, you just follow your documents. You don't have to go through the veto process. You still have to hold a meeting and allow them to consider the budget, but no veto process. Yeah?
Are we, maybe not here, but are we later on going to get into a discussion of quorums for our meetings?
Yeah, we'll talk about quorum. Yep. Okay. But because you asked about it, I'm not going to talk about it.
We'll talk you off.
We'll talk later, I'm sure. Okay. Love this. Let's recall the HOA board. The board must go. Who will volunteer to run for the board? Not me. Someone else should do it, right? How many of you have a difficult time getting people to serve on the board? It is so hard. It is so hard. But, you know, you have to have a board to run things. So this section of Kiowa, this next one actually is the removal piece. The first one is just about audits. And it is applicable to all associations, all CICs, and it essentially lists when an audit by a CPA is required. And that's only if both of those are met. The association has annual revenue or income of at least $250,000, and it's requested by at least a third of the owners, a third of the units. So you have to have both of those to be required to have an audit. Or, I didn't put it up there, or your governing documents not required. So look at your governing documents, look at your bylaws in the treasurer section. I've seen it there many times. So this second piece is about removal. Just for post-Kiowa associations, if homeowners want to remove or recall the board, regardless of what your documents say, this is the standard for removal, the approval requirement. 67% of all owners, as long as a quorum is present. So once quorum is met at a meeting, 67% of those who are present at the meeting have to remove them, regardless of what your bylaws say. Your bylaws might say a majority of all. Just ignore that if you're a post-Kiowa community. This is the requirement. Yeah.
How does a board member get off the HOA board?
The board member can never get off the HOA board. You did last time. You're gonna serve till you die. I'm sorry. Okay, how does the board member get off board? Why? You just resign. You can resign at any time.
Okay.
Yeah, a lot of you didn't know that, huh? You can actually resign. You know? But please don't, because they can't get people to serve. Yeah.
I'm sorry, this has gone around the whole room, and I don't know about anybody else, but the last column, have you drafted your updated HB 122-1137? What is that?
Okay, I'll talk, the 1137 policies, a couple years ago, or last year actually, the statute was revised, Kiowa, to update collections, enforcement, and conduct of meetings policy. Those are those three 1137 policies.
That stands for House Bill
Okay, thank you.
1137.
And Amanda's gonna talk a little bit about that, okay? All right, so that's just, that's removal. If you're a pre-Kiowa association, then you just look at your removal requirement in your documents and follow that. All right, so we're now on to meetings, owner meetings. Everything is in 3-308. This is all associations. It's gonna list things like time frame, no earlier than 10 days before the meeting. That's notice has to go out, and no later than 50 days. A lot of older bylaws say 60 days, so be careful. It's now 50. Also, the method of notice, and we're just talking about owner meetings. That's really often just one meeting of the year, the annual meeting. So the new thing that was changed several years ago is not only do you have to mail that notice, but you also have to physically post it somewhere in the community, somewhere conspicuous. So if you have an annual meeting, put up a sign somewhere, put something on the bulletin board if you have one. At least 24 hours, maybe more, but at least 24 hours prior to the meeting, discussing, when it is, what's the location, and all of that. The other thing you have to do now is email that notice if a homeowner requests email. So that's not in lieu of the mailed notice, that's in addition to the regular mail notice. Yes.
Under this, what about, okay, like we do our 30 days before our annual meeting, and we send an email out with the document, plus it could be on our webpage, and do we have to do both of those?
You don't have to put it on the website, but that's encouraged.
Okay.
You do have
keep track
to.
of all of our meeting information.
I'm sorry?
We just do it to keep track of all the
Yeah, I mean,
so our boards have it all.
I would say just try to be as transparent as possible. I'm telling you what the minimum requirements are, but I'm in favor of being as transparent as possible. If you have a website, put it on there too. Even though it's not required, it's encouraged. The only thing that's new is really electronically is the email piece. If email is something that you can provide as an association and an owner gives you their email address and requests email notice, and you have to give them.
So the hard copy only has to go to those who don't have emails.
The hard copy has to go to everyone.
But we do have to give everybody a
Yep.
hard copy.
The email is in addition
And we
to,
talk to those who go green and don't want to stay.
you know what, this comes up all the time in the legislature, and it gets killed, the bill gets killed for some reason. I'm sure it's gonna be law soon, that you're gonna be allowed to do it electronically. All right, special meetings of members, 3-308. This is, again, just owner meetings or owner/member meetings. Let's say in the middle of the year, the owners demand a meeting. They want to recall the board. That's a special meeting. That means something other than the annual meeting. And that happens, and it's usually because they want to recall the board. Now, I know that you were asking how to get off the board. I knew you'd start laughing. You're like, yes, how do we do this, right? Okay, how do we get people to petition this? So,
Meeting be this evening.
yeah. So special meetings of the members, they can be called at any time by the president or by the majority of the board, or by 20% of the voting power, which means usually it's 1 vote per lot. So 20% of the lots or the units have to sign a petition saying, we want to hold a special meeting for whatever reason. The reason why I bring this up is because many bylaws have language that's contrary to that. And they say something like 25% or 30%. 20% is the cap. You can't have more than 20% have to sign that petition. So just realize if your bylaws say 25, 30, 40, read it as 20%. And that just means to get them to... Yeah. Sure. Yeah. So that just means how many have to sign it, then you hold the meeting. That's not to remove the board, but just to hold the meeting itself. The other thing in there, which you have to also realize is, and it's in the statute, is that you have to provide notice of a meeting within 30 days of receiving that signed petition. So just, it's not, I didn't put it up there, but that's another time frame that you have to know. Once you look at the actual statute, you'll see all these requirements. Okay, we're moving on to board meetings now. Actually, maybe I didn't talk about quorum. So what was your question about quorum?
Oh, the quorum as far as.
It's next. Oh, it's the next one, sorry.
Next one, by the way.
Sorry, shush! Sorry. Okay, board meetings, open meetings. All board meetings are open unless to the owners or their designated representative. So they can say, my tenant can go to those board meetings. My attorney can go to those board meetings. My real estate person. They can designate somebody to go to the board meetings, and all they have to do is send you an email saying, I want to designate this person to attend my board meetings, to attend your board meetings. So all board meetings are open to owners or their designated representative, except when in executive session, otherwise known as closed session. So there are several categories that you can go into closed session for. Please take a look at 3-308 because that lists all the categories. Things like when you're talking about delinquent accounts that you want to turn over to your attorney. Things like attorney-client, if you have your attorney there, you can go into closed session. If you're talking about the management contract, you can go into executive session. But make sure that you're only in executive session for one of those categories. Once you go in, the minutes of that executive session should say something like, it's 7 p.m., we're going into executive session to talk about whether or not to hire this particular management company. Then you discuss it, you can take action if you want to, you can vote on it in executive session, but then the minutes coming out will be, it's now 7:20, we're out of executive session, and we decided to hire the management company. But none of the notes that happened during that executive session are open. Only those minutes of going in and coming out of executive session. That's the one thing you also have to remember is you go into executive session for one of those categories, but you want to make sure that once you stop talking about that language, that category, that you come out. You don't want to keep talking about all these other things that are inappropriate for executive session. Yeah.
So if notes are taken during that period, are they ever available?
So the question is, if you take notes during executive session as a board, are those open for inspection? And we're coming up on records for inspection here. No, because they're not part of the records that are open for inspection. However, they might be discoverable if you get sued, but they're not statutorily open before inspection.
You have to join the board to see them.
You have to join to the board, yes, ooh, wisely. Oh my God, yeah. How do we get around, what's the workaround for this?
We had a meeting about you, you have to.
Yes, we had a meeting about you have to join the board. Okay, the one thing, I said you can take action in executive session, but the statute actually says you can't adopt any rules or regulations in executive session or amend the articles or the bylaws. But really, you ought to be, you're only in executive session for certain categories, so there's not much to take action on, but just realize once you're in there, you can take action, except for those three things.
And then you can have work sessions for the board.
Oh, that's a great question. I was wondering if somebody's gonna talk about work sessions. So work sessions, can you have work sessions, right? Has anybody heard of the term work sessions? Okay, so that is not recognized in Colorado. There is no such term as work session. Bad. Or bad, no. That's fine, it happens. That's why you need to be recalled. That's why you need to. No, but it happens all the time. I mean, here's what a working session is. The statute says all board meetings have to be open to the owners. What's a meeting? The statute doesn't define meeting. So some have argued that as a board, if we're just working through topics or discussing them, but not voting on anything, it's not a meeting. So hence, working session doesn't have to be open, okay? So I think you can make that argument today, but I think that's going away pretty darn soon. So get very used to the idea that anytime any directors get together to discuss HOA business, it's probably going to be called a meeting and considered a meeting because that's the way the legislature is going. Transparency. Okay? Yeah. Or
my question is, we've had a couple jokes about, how do you get off the board?
Yes.
Nobody wants to be on the board. We have a bylaw that says that you can have 5 to 7 board members.
Okay.
Traditionally, there's always only 5 allotments of slots on the ballot.
Okay.
How do we get our board to say, okay, we're gonna now have 7 board members because we have that many people interested in serving?
Sure. Okay. So the question is, so a lot of bylaws have a range of directors. You can have, they might say something like, you can have anywhere from 3 to 7 directors. And what she just said is hers has always been 5. But there are more people that are interested. So, how do we get it to be increased? So first of all, look at the bylaws provision, because usually the bylaws provision itself will say the board itself, by board vote, can vote to change that number. And it'll either say the board can do it, or it'll say the bylaws can be amended to change that number. But if it says the board can do it, then you gotta convince your board. If they don't wanna do it, they don't have to do it. Yeah.
So, sorry, another question. The question is, like right now, as you know, we're going through the process of trying to get our documentation updated from 20 years ago.
Yes.
And we as a board have been going through it all and doing, it hasn't been an open session. One of the rules we do have, and the board members know, we do not represent ourselves, we represent the community.
The community as a
And
whole.
So we have to look
Yes.
at it from a community perspective.
Sure.
There was talk about should we open it up and let people come. We were like, no, because unfortunately a lot of people come in with their own ideas, and also they haven't spent the time that we've been spending going through all of this, where we're getting to the end where we need to get it revised.
Right now, I think you can do that.
We can do that.
I think you can do that right now because you're not voting on anything, and I think you can make that
And what we'll do is,
argument.
once we do it, when we get the final package,
Yeah.
we'll send that out to the community before the annual meeting.
Yep.
And give them time to review it, with whatever questions they can send to us
Yep.
and so on. And then we'll present that at the annual meeting and do a vote.
Yep, it's all good.
Okay,
Yes. Okay.
thank you.
Sure. Okay, quorum. So I just put up the default quorum. If quorum is counted, well, somebody tell me what quorum is. What does that mean?
Representation.
A number, any number, pick a number. No, what does it stand for?
The number of people that you have to have present in order to conduct business?
Exactly, the number of people you have to have present in person or by proxy to take action. So your bylaws typically say what quorum is, 10%, 20%. Sometimes your declaration, be careful, sometimes your declaration might say quorum for particular actions, might be higher, so be careful. If none of your documents say anything, they're silent, then if you have less than 2,000 units, it's 20%. So less than 2,000 lots. If you have more than 2,000 lots, 10%. What was your question on quorum? Did you have one?
No, I mean, that would be, yeah, because we have a different, you just mentioned some position, 20% if you have 2,000, we only have 63
Yeah.
Homes, so.
So yeah,
our
just
quorum's
look at your
higher.
documents
Well,
first.
the part that's frustrating is when we have to have a meeting,
Yeah,
hopefully we get a quorum, we do if we provide food, but. we'll
Provide
also-
food then,
We have to do it on Zoom, so we'll be doing it on Zoom,
Yeah.
but, is we get so many people that do proxies, and then they give us the proxies, so we as board members voting, and I get to the point that says, we're voting for this, if they don't wanna show up at the meeting, I'm gonna go with who's there, we're gonna vote regardless of the proxy, because I'm still voting for it.
yeah, I mean, if they're giving you the proxy, you can vote however you want if it's a
Right, but we
proxy.
still have to get, what is 32%? Of-
Yeah, I mean, it's frustrating if you have a high quorum, because you cannot take action, other than budget veto, that's the only thing. You cannot take action, you can't elect directors if you don't make quorum. Just be careful.
We can revisit our quorum in this process.
You could always revise your quorum and lower it, and try to get it lowered, but you can't take action if you don't make quorum. Okay, voting on proxies is in 3-310, all associations. Just realize that the law right now says that if you have a contested election, then you have to use a secret ballot. Contested election just means more people are running than positions open on the board. Does that ever happen? I don't know, maybe it does. But if it does, then it's contested, and you have to do it by secret ballot. So just recognize if you are on Zoom having an annual meeting, and if you can't preserve the secrecy on your virtual platform, you can't have that election on Zoom. If it turns out to be a contested election, and you can't preserve the secrecy, which means you can't know how the owners voted, then you cannot conduct it via Zoom. You have to stop it and say, we can't conduct it. We'll have another election at a later time that's using secret ballots. And then votes made, the only change in the proxy language is that proxies are now capped at 11 months, which means that you can give your proxy to somebody, and you used to be able to say for however long they want. They could be there for 3 years, they could use it. Now it's capped at 11. One question.
Yeah, one question. So if somebody assigns their proxy to someone else,
Mhm.
does the person who owns that ballot have to state how they want their proxy person to vote for them?
So
Or
the
does it
question
not
is,
matter?
if you are giving your proxy to somebody, and the question is, do they have to state how to vote on a particular action? They do not. You could do a general or directed proxy.
Okay.
We will talk a little bit about that. Yeah, we're gonna talk about a little bit about that during
Because
the
that's come up.
couple times.
And
So finally, the last thing that was changed a few years ago is ballots, all ballots, not just the contested election ballots, but all ballots have to be counted by neutral third parties. The statute doesn't define neutral third parties other than in the scenario of an election. For a neutral third party in an election is not a candidate and not a board member.
Yeah.
That's pretty much it. So just pick somebody from the audience who's not a candidate or a board member to count those ballots.
So they have to
Yes.
use paper ballots?
If it is a contested election, then yes, because you can't preserve the secrecy in person if you're in person.
Unarmed.
Yeah, but if you have a ballot and not, if you have the ability to just raise your hand and it's not a contested election, then this doesn't even apply. Okay. But if you have a written ballot that you're using, neutral third parties.
Melissa, I
Oh,
would
yes.
like to ask this gentleman a question, because you and I have talked many times in the past. We have 40-year-old documents,
Yeah.
and we
Yeah.
want to rewrite them, but
I
our
know you
board
do.
doesn't want to spend the money.
Well, what is
How
wrong
do
with
you
that board?
convince your
We haven't
board?
spent the money yet, we're going through line by line, and we have it
So you
online
didn't
where we
use
put in all of our.
Melissa to go over and
We will.
You will.
We're first.
Why haven't you spent the money on me yet? You write your document.
Because we're sure what money we want.
It's too much money, they say. They
It's
don't
not,
understand
it's, you're spending a lot up front, but then you don't have to do it again for 30 years.
Yes.
That's good. All right, 50 years.
Can I ask a question?
One last question, yeah, we're moving on.
About proxies.
Yes,
Can the board tell homeowners to send the proxies to the board?
you know what, I am going to allow Amanda to, she's gonna talk about proxies in her presentation. And, you have reached your quota. Stop raising your
They
hand.
call them, if they don't do a proxy, just call them to the meeting and count them. as-
She'll talk about proxies in her presentation. I knew you weren't
I'll be
listening.
quiet.
All right, insurance. Post Iowa associations. This is a big problem in Colorado, particularly with condos and townhomes right now. So if you're in a condo and townhome, your premiums increased 300 or 400%, unfortunately. But for post Iowa condo communities and post Iowa communities in general, you have minimum insurance requirements in Kiowa of what you have to insure. So this is a pretty lengthy section, and I just need you to look at it. Look at the section 3-313 for post Kiowa. It's really applicable, and there's a lot, very impactful on condos. So if you have a post Kiowa condo community, make sure you look at that section. You should, if you're a Kiowa condo or townhome community where you might have a lot of claims, water claims on the inside of the units and all that, you really ought to adopt a claim submission, allocation of deductible policy, which the statute allows you to do, which essentially lays out the process for adjusting a claim. So you avoid the situation where an owner calls the insurance carrier directly and says, I want to file a claim on behalf of my unit in the association. To avoid that, you adopt one of these claim submission procedures, and you can also allocate how those deductible payments are paid. So for condos, we're going to be doing some more materials and blogs and everything on this topic, so just keep an eye on our website and get onto our website to our newsletter, and you'll see some of these topics coming up. Associations insurance is primary in condos, so again, this is really more about condos. But post-Kiowa associations have to have fidelity coverage. Fidelity is theft insurance. So if any board members embezzle or management company embezzles, you are required to have fidelity insurance if you have more than 30 units. And it has to be at least 2 months of assessments and everything in reserves. So these are, again, oops, that's important. D&O, directors and officers, is not required. That's directors and officers insurance to defend individual board members. It's not required in Colorado, it should be. You have to have D&O insurance because all it takes is one lawsuit against you individually and it's gonna cost a lot to defend it. So make sure, there's a lot of information on our website about D&O policies as well. Okay. Assessments, just so you know, there's been some changes under HB 221137 for collection policies, which we won't go into too much detail about that, but I wanted to point out some of the specific provisions in Kiowa that you should look at. Definitely get on our website about if you have problems with delinquent assessments, there's so much material on our website about HB 221137, which was passed in 2022, and it completely changed the process and requirements for collecting delinquent assessments. A lot of the authority for collections and the limitations are in both of these sections of Kiowa. There's one other section too, but this second part that covers a lot of what you have to do now. You have to have a compliant collection policy. You have to offer 18 months payment plans for delinquent assessments. It used to be only 6 months, now it's 18. So there's a lot of new things under that law. If you just get on our website, just type in HB 221137, it'll tell you what you have to do. But the first part up there I wanted to show you as well, particularly for post-Kiowa communities, because this is important. The 3A is just limited common element expenses, so actually all of these are important. If you have an association and you wanted to be able to charge back a particular expense to just those units that benefit from that expense or that are tied to that expense. So for example, you have 20 condo buildings and only 2 have balconies. And you want to be able to charge back the balcony repair expenses just to those 2 buildings instead of spreading it across the entire community. So if you're post-Kiowa and you don't have language saying that the expenses that benefit less than all can be charged back to them, then you have no right to do that. You have to spread all costs to all units. So most newer documents have that language, but a lot of post-Kiowa documents don't have that language, so be careful. You can't just automatically assume that you can charge a common expense to less than all units just because it benefits just those units. You have to have that language, yes?
Jim was going to ask this question.
Oh, okay, so he's delegated to you, yeah.
When you talk about collections and you talk about, having to have an option for 18-month payment, Monica, we were interested to know, does that include interest on, how long it's have to?
Yeah, so, the statute does not mention whether or not interest can or can't be included. But I will tell you that based on the matters we've had before the courts lately, it is not looked upon as favorably for the insurance, oh my goodness, for the interest or the late fees to continue to accrue while the owner is in the 18-month payment plan. So, it'd be one of 2 things. You can either continue the late fees and interest, but keeping in mind what that balance is going to be if it's paid in full through the 18 months and then waive that amount at the end, the late fee and interest amount. Or don't let it accrue during that time period until and unless the owner defaults. And that's going to be your safest option. Otherwise, they're never going to catch up.
Because it can overlap, and you think after a while, how many years you grow to find.
Right. And it's, so the other thing though to keep in mind is the payment plan can and should include ongoing assessments. So they're going to have let's say I'm $2,000 behind, I'm gonna pay that off over the 18 months, plus keeping up on my regular monthly or annual or semi-annual assessments. Are there any other questions from not Jim?
Yeah, exactly. I need a sign. All right, let's move on. We're almost done with Kiowa. Okay, so the next one is association records. This is really, really important too, because records, well, it's really important because now the law actually lists the records that you're supposed to keep. Prior to 2014, the law just said, you have to keep association and financial and other records open for inspection. But it didn't list what those records are. 3-317, and this is all of Kiowa, lists in section 1 all the records, the sole records that you have to keep open for purposes of inspection and retention. So now we actually have a definition of what those records are. The laundry list of records, some of it is a little bit ambiguous, but it's better than it used to be. Now, subsection 3 of that says records that may be withheld. So those are the records that you have discretion on whether or not to provide inspection. An example would be, attorney-client privilege documents. We always say don't disclose it. If you want to disclose some kind of opinion, ask your attorney first. But you have discretion to withhold or send it out. Another one is architectural review request documents, not the actual yeses and nos. So if somebody submits an architectural review request and you reject it or you approve it, those actions to object or approve are open for inspection. That's actually in the first list. But all the documents and the plans and everything else outside of the actual approval or rejection is in that second list of what you can withhold. So just look at that. And then the third, 3.5, those are the records that must be withheld. So just be careful. Things like bank records, those kinds of things. I was going to say that there was a section, but that's actually 1. In subsection 1, it says that all email addresses of board members are required to be open for inspection, because the legislature wants owners to be able to directly reach the board. But 3.5 says owner emails are not to be disclosed without the consent of the owner. So for example, if you have a community handbook, if you have a community handbook and they voluntarily give their information and they consent to allowing it to be provided, then you can do that. Sometimes what I'll see is, so be careful if you're sending out, for example, e-blasts. Don't put the email addresses of the owners in the blind copy section. Don't disclose to all the community those emails, because you are required to withhold them unless they consent.
May I ask two quick questions?
Absolutely.
The item 3, records that may be withheld, now that if you elect to withhold something, that's withholding it from everyone.
Yes.
You can't selectively give it to some.
You can, because you can disclose it if you want to.
Just
If it
certain
may.
people?
Yeah, if it affects them, there better be a reason why you're only giving it to them, for example.
And then we were going to go with the generic email address in order to not have our private, is that
Yes,
doable?
so email addresses, because email addresses of board members and officers are required to be provided to owners upon their request, we always say don't use your personal email address, don't use your work email address. Have a generic address for the board position, things like, treasurer at happyhollowhoa.com or whatever, just something generic. Because otherwise, if you're using your own personal email addresses and you get sued, they're going to be able to look at all your email addresses. Yeah.
What about owner directories?
So if you have an owner directory and the homeowners voluntarily give their information, that's not enough for you to say it's okay to distribute that owner directory. They actually have to sign something, a consent saying, I give you consent. And you need to put it in your file for me to distribute it to the entire community. So when you're putting together an owner directory, make sure if that information is open to the entire community, make sure every single name and phone number or email address is actually consented to in your files.
Could it just be the owner's name and property address?
Yes, so one of the things in the first list of records that you are required to provide upon request is a list of the owners and their addresses. What we're really talking about is email and phone. Email and phone must be withheld unless you get consent from those owners, except for board members. Board members, the email address is open. Okay, so the other things under 33-317 really have to do with time frame to provide the records if they request. And you can charge for copies and for time to put together copies. Time frame is within 10 days of the request or 30 days if you're going to present it at a meeting. So just make sure that you're within those time frames. Look at 3-317, it discusses it. There is penalties now. They changed the statute to actually be able to fine the person, the association that doesn't provide it within those time frames. So take a look at the statute. And then what I mean by no obligation to compile is that you only have to give the records that you put together as part of your HOA business. So if somebody comes to you and says, I want to see all the architectural review applications or denials or approvals that are on this street and only this street, or that were only done within a certain time frame. If it requires you to compile something that you don't typically put together, you're not required to provide it in the manner they request. If you typically put together that record, then you have to give it as you put together, okay? All right, one last thing is under 3-401, registration of associations. Associations, all associations that are not exempt from Kiowa, remember those 4 exemptions that I discussed at the beginning, must register annually with DORA, the Department of Regulatory Agencies, the real estate section. And if you just type in Colorado DORA, it'll come up. So, but if you're looking for specific links, you can also go on our website. But you have to register every year, unless you fall within this exception. Oh, well, no, you have to register every year, but you don't necessarily have to pay the fee if you fall within this exception, which is your annual revenues are $5,000 or less. So if you're a smaller association that doesn't get over $5,000 in revenue, then you don't have to pay the fee, but you still have to register. Yeah?
Are you calling, fees,
It's the state's fees, and it just got increased. 50 or 75 or something, I don't remember how much it is now, but it's a fee that Dora charges.
And guys, keep in mind, this is separate from the Secretary of
Oh, right.
State's annual report. That the association has to file with the Secretary of State. It was about $30. This is going to be separate. One affects whether or not you can continue operating as a business. The other is going to affect whether or not you can continue as an association. So it's two things.
And if you don't register or pay the fee, if you're required to pay the fee, then during that time, you're essentially suspended from lien rights, so collection rights, as well as enforcement rights. So make sure you pay the fee and get current if you have paid in several years. Yeah.
Real quick,
Oh, wait, it's you. Yeah.
if we haven't been paying for it, we just found out about this recently, because we're not, it used to be paid for, then that
Oh,
was
yeah,
short.
yeah.
Do we have to go back and pay?
They're gonna still make you pay what you didn't pay, but they're not gonna penalize you at this point. I did ask for whether there's any fines because you're late, for example. They don't tack on anything, unlike the Secretary of State's website, our office that does fine you. Okay, one more and then we're moving on to nonprofit act.
Well,
Yeah.
I just actually went in today. And
Oh, and you paid it up? You paid
I
up?
finally got registered and did all that I had to do.
Uh-huh.
And I paid it, and I asked her, do I have to pay for the years we didn't pay, because we missed a few years.
Yeah, they didn't make you?
No, she said I didn't
Wow,
pay
well,
for a
then
year.
I stand corrected, that's great.
So, yeah, that's what I thought. It was $43.
We got it.
We're thinking 50. Okay, and I'm turning it over, I'm gonna stop talking now, and I'm gonna allow Amanda to talk a little bit.
Well, it's a time you've all been waiting for. Nonprofit Act. You thought Kaya was exciting, here we go. This applies to all associations, so I don't want to hear any of that pre-post Kiowa business in this section, all right? Y'all gotta do it. There's, of course, numerous provisions throughout the Nonprofit Act, but we're going to speak just about a couple that are most pertinent to our association. So the first one is going to be found under CRS 7, so that's Colorado Revised Statutes. Instead of looking at Chapter 33 or 38 or any of the others, you're going to look at Chapter 7. And under Chapter 127.109, 7127.109, it's going to talk about whether or not you can conduct a vote on a topic outside of actually having a meeting, so a vote by mail. All right, and so what it says is that unless your bylaws state otherwise, you can take action without a meeting under this section, as long as you deliver a written ballot to every owner in the community that is entitled to vote, so if they weren't suspended or they're not an owner, et cetera. And whatever action you take under this section is the same effect as if you had taken it at a meeting. So what you can do if you have a problem where you have owners who are interested, but maybe you live in a community where many of them reside out of state or out of pocket, or you have owners who are not inclined to show up for whatever reason to meetings, but you think they might still be interested enough to actually vote and send in the ballot, you can do it this way under the Nonprofit Act. Some of your documents are going to have provisions as well, but the default is if you have documents that do not speak to action without a meeting, you go to the nonprofit code. So when you send out this ballot, you have to send two things. One's going to be the solicitation letter, which is going to have information about what you're voting on. And the other thing you're going to send to the owner is the written ballot. Don't you leave. So the written ballot must state the proposed action that you're taking. So for example, if you're conducting a limited amendment, let's say you're a community that wants to amend regarding short-term rentals, you would have a ballot that says, I vote to approve the short-term rental amendment to section blah, blah, blah of whatever declaration it is, or I vote no. And then it's going to have information for or against, and then of course the owner signs and dates it. The solicitation letter that must go out with it has to specify the number of responses needed for quorum, and then the actual percentage needed for approval. So if your quorum says 20% in your solicitation letter, you should calculate how many that 20% actually is needed. So that's the number of ballots you will need to get in. And then the approval percentage is going to be, if your documents are silent, 67%, but whatever percentage is needed, whether it's majority, et cetera. In the solicitation letter, it must also contain the deadline, which can only be 60 days maximum away from the date you're sending the letter, so make sure your letter's dated appropriately. And then it has to have the time it's returned. So a lot of times it'll say it's due on September 16th by 5:30 p.m. and it'll tell the owner where to either mail or fax or email the ballot in. If the owner ends up showing up, so to speak, if you decide later that they show up and they say, I want my ballot back, there's no process to actually revoke a written ballot like there is with a proxy. And then of course the solicitation letter must contain enough information to actually allow the owner to make an informed decision. So that doesn't mean that you need to send every document you've ever had, but it certainly needs to have a copy of the proposed limited amendment, for example. The letter will state that we're voting on the approved or the proposed amendment to restrict short-term rentals in the community, et cetera, et cetera. So enough that they know what's going on, copy of the amendment, copy of the ballot. Okay?
Question?
We're not accepting, okay, go.
Are the written ballots private, or can the board keep those private? Meaning, we have a controversial issue, and there's concern that people are going to look at ballots and who voted which way and take negative actions against them.
So the ballots are actually any of the actions about voting you have to have available for anyone to review for a year after the action was approved.
Okay.
So, okay. Yes.
So I have this is a kind of a general question, but when we did our CCNRs, the deadline for getting the votes in was 5:30 p.m. on a Friday on a certain day. And I always thought that was like midnight, by mail, and I wanna know, is that a principle in business under the UCC that's rather changed, or how did that happen?
So the association is going under its governing documents and under Kiowa, which is going to specify the date and time. You could make the date and time 11:59 p.m. on Friday, as long as it was at 60 days, but if it's 5:30, it's 5:30. So it's not changing the UCC. It's just not acting underneath the UCC, the Uniform Commercial Code, because we're talking about voting within the homeowners association. So you're not enacting the business portion of the UCC. So if that's a concern for you, you would want to date your letter such that either that deadline is Friday at 11:59 or Monday or whatever. You can work with that as long as you're within the 60 days. Yes?
For the ballot being available to anyone to see, does that include election dressers? If someone requested to see who voted for who?
So if an owner were to make a records request, you would go by the records that are allowable underneath that statute. So the year limitation is going to be that year on action taken by vote. So that's going to be primarily your amendments to the declaration, amended and restated declarations, et cetera. And I will let Melissa handle the election.
Well, I was also gonna say that if it's a contested election, it's secret, but they can see the ballots, not gonna have any identifying information.
They can just see the number of for and against.
If
You said when you mail a ballot, you sign it.
Yes, and if it's a contested election and you're doing it by mail, you're gonna have a double envelope system, it's gonna be secret. So you're still not gonna know who voted how.
Yes.
What I thought she might have been asking, but I might be wrong, is does a homeowner have the right to know how a board member voted?
How anybody voted, yes.
Yeah.
If it's contested though,
But no, how a board member, usually the votes are just pass or fail. fail, because a lot of times the.
Oh, I thought you were talking about at an
there's
owner's
no
meeting.
roll call vote.
I was thinking you were talking about an owner's meeting. Are you talking about an owner's meeting or a board meeting?
Just like an owner's meeting.
Owner meetings, then yeah, board members or homeowners, they can see their vote too. But at a board meeting, there's usually no,
It's gonna say 5-4 and
5-4.
4 against.
No roll call
Right.
vote.
right.
Okay.
Does it have to be included in the minutes?
No, you can go ahead. It depends. So if you're, for example, if we're doing collection turnovers and you had to go into executive session to vote for that, it's just a recorded vote of 5-4 against, we approve, etc. If you are doing an annual meeting vote or a limited amendment vote, you would record the number of approvals versus denials, and every ballot that comes in is going to have one or the other. But if it's a contested board election, then we're in the secret ballots, which is a different animal entirely. Confusing enough so far? Come on, go ahead.
At an annual meeting, you're voting for board members, and let's say there's somebody who doesn't want to. How many, is it a percentage of the quorum that would have to vote against it to say that person's not on the board? Or how do you determine how many votes would say no, they aren't on the board?
So the number of votes needed to recall a person are the same number of votes that are needed to elect that person in the first place. So if your documents are silent, or your documents, let's say they don't specify anything, then it's gonna be that 67%. Differently from that, if you're having an election and it's just this person's running, if no one's running against them and they get one yes vote, they're on the board. If it's a contested election and they get 51% of everybody who's there voting for them, they're on the board. So there's no requirement that it's, it has to be X amount of people saying no.
Thank you.
All right, so proxies. So we talked about proxies under Kiowa, and Kiowa states that you'll have the proxy language in your bylaws generally. However, if you don't, it's going to revert to the nonprofit code. So under 7127-203, it's going to talk about proxies for homeowner meeting. Now there's a separate section under 124 that's going to talk about proxies for board meetings, all right? So we gotta keep them separate. So under your owner meeting, a member, unless the bylaws state otherwise, unless otherwise provided for in the bylaws, a member entitled to vote can vote or appoint a proxy. So then the question is, well, how do they do that and who can they appoint? And there's nothing in the Nonprofit Act that specifies who can or cannot be appointed. So I can appoint my neighbor, I can appoint my spouse, I can appoint my attorney. Conceivably, I could appoint my child. There's nothing in there that really states that the person has to be over 18 or has to be an owner in the community or anything like that. The second part of that is that you can either sign a proxy appointment form or to appoint a proxy, or the owner can simply just provide a written statement saying, I'm appointing such and such as a proxy. So don't get into an argument with an owner if they send an email and say, I'm appointing John Davis as my proxy, saying, well, you didn't fill out our form, because they don't have to. The form is just one way you can do the proxy. Certainly if you have a question of apathy in your community and you want to get quorum in, I would send out a proxy form. I wouldn't rely on people to just email you because they're not going to, okay? At any rate, the form should specify, or the written statement should specify who the proxy is. It should be signed, although there's debate under the statute, because the statute doesn't really talk about signing. It talks about that it must be dated. There must be enough information if it's sent in via a written non-form or form that you can tell who it's from. So it's not just, well, we think this is the owner down on 51st Street, but we have no idea. And then it cannot be for longer than 11 months, because remember we talked about the law changing. Now you can, as a board, you can do one of two ways with a proxy. You can either say we're going to do a general proxy or we're going to do a directed proxy. So what's the difference? A general proxy says I'm going to give my vote to Melissa, my proxy. She's going to act for me, and she's going to vote however she sees fit. That's a general proxy. A directed proxy is on the form, I state, Melissa's my proxy and I want her to vote no. And now she is bound by that to vote no. I recommend to you that you be very careful anytime you're doing a directed proxy, because if an owner challenges the association that their voting rights have been restricted, the burden is on the association to prove that it's not. So you can do directed proxies, but I wouldn't make everything a directed proxy. You can also, if the proxy is left blank, it's not valid. But what you can do is put in a sentence in there that says, if this proxy is left blank, it will revert to the board president to hold the proxies, to do the vote. Now, unlike written ballots, proxies can be revoked. How does that happen? Either the owner can write to you and say, I'm revoking the proxy, or the owner can show up at the meeting. And if they show up at the meeting, because you're going to be checking off the list of owners coming in, you gotta keep track of who's there and who isn't, and you see, well, we had a proxy from Bob and now he's here, you rip up the proxy because he's gonna be voting here, okay? All right.
Question.
Yes.
Amanda, to my earlier question of, can the board direct homeowners to send a proxy to the board, so the board's voting?
No, you cannot restrict the proxy to state it must go to a certain person. The only option, if you, and I know it's confusing, the only option you have is to say if it's left blank, it will revert to such and such. But you can't say, if you do this proxy, it's going to this person and you must vote this way. Okay, so separately from that, now we have board meetings. So if you're at a board meeting, board of directors, and you want to do voting by proxy, it's a little bit more of an involved process. First of all, the bylaws must specifically allow the board to do proxies at a board meeting. Secondly, you as a director may only appoint another director as proxy. You don't get to choose, you get to choose which director, but you can't just appoint anyone in the community. And then 3, the proxy has to be directed. So you can't say, I don't care how you vote, just vote, you're my proxy. If you're a director, you're appointing to another director, and you have to tell that director how you're going to vote. It's a little different, it's a little more restricted. All right, speaking of boards, I should have put more cartoons in here. Sorry, guys. All right, so now we're going to jump over to 7-128-101. It talks about who's on the board. And the answer is darn near anyone unless the articles state otherwise. So unless your articles, sometimes you'll see articles that say, you know, only so many people can be on the board, or only certain people can be on the board, etc. But under the law, anyone can be on the board. How many board members? You're going to look in 2 places. One, you're going to look at your bylaws. It's going to specify how many, the number of directors, or a range. Sometimes they'll say between 3 and 5 directors, or 7 and 9 directors, or something like that. And then the terms. So again, you're going to look to your bylaws. It should have your terms of your directors in there, but if it doesn't, then the default under 128-105 is that the term would be for 1 year. There's no prohibition against serving successive terms. So if you do want to get off your board, you will have to resign because it's just going to keep going. But nobody would want to do that. We already talked about that. Yes.
So, since if the declaration and the bylaws are silent on, maybe 2 people in a unit, want to be on the board or aren't on the board, is that allowable?
If the bylaws and the articles don't specify otherwise, then yes, it would be allowable.
It would be allowed.
Thank you. Okay, so now we're talking about board action without a meeting. So previously we talked about voting without a meeting. So this is going to be board action without a meeting. The prior topic was member action without a meeting. So under board action without a meeting, you have to check your bylaws first. Because if the bylaws state otherwise, then you would not be able to do so, okay? So what do you have to do if you want to have a board meeting without actually having a board meeting? You have to send out written notice. It can be via email, it can be via letter, you can send it in an owl. It's going to say the action to be taken. It has to say the deadline, date, and time by which the director must respond. It has to say that failure for the director to respond is considered a vote in abstention, that they're abstaining from voting. And it has to say that if they fail to demand in writing challenging that the proposed action may be taken outside of a meeting, that the action will proceed. And then if you get that as a director, you have to do one of the following. You either have to vote yes, you have to vote no, you can abstain in writing, and remember, if you don't do anything, then it's considered abstaining. Or you can just sit back and say, well, I'm not challenging at all, and then it moves on without you. The action, whatever action you're voting on, may be approved if the yes votes equal or exceed the maximum that would have been required at the in-person meeting anyway, if all directors were present and voting. All right.
I'm assuming if one person wants the meeting, it's gonna have to happen.
Unless a different director sets forth and says we shouldn't be having meetings for, or this action outside of a meeting for this reason. And then the board will vote on that and decide either to take it in or to continue having it without the action, without the meeting.
But if one board member wants a demand for a meeting,
There's no requirement that you have to or that you can't, it's the reverse. It's that if you decide to do it without the meeting and a board member challenges it, that's when you would have to move forward with the process. In the back, thought I
So,
saw it.
so that eliminates any quorum requirements, the quorum's 100% in
Well, it doesn't eliminate it. You would still have to have the same number needed as if you had the actual meeting. So if you have, because of the way it's written, if you have 5 directors and in a meeting you would have to have at least 3 present. On this, because of the way it's written, where it says if they don't respond, it's considered absentee, then you would kind of get a backdoor way around it.
Okay, so in that case, if 3 of them abstain, then there would be.
Well, however, I don't know how many people are on the board, but let's say there were 5, you'd still have 2 people voting. It'd be a tie probably, unless you both voted yes or no. Yes.
So suppose you have owners who want a particular amendment brought up, but the board is saying, no, we're not going to address that. How do owners have any power in persuading that board to address an issue? For example, community parking, where you want to limit commercial vehicles being allowed in community parking. How owners have that power? You know?
So first of all, the owners are gonna wanna be involved or showing up to the meetings, expressing their opinion. The board represents the owners and quite frankly serves at the pleasure of the owners insofar as they're elected. I know, just stay with me. So, I use that term very loosely. So if you're an owner and you're unhappy with the directors, you don't feel that your directors are listening, you can do a recall, because if you remember under HOA, when Melissa was speaking, that a special meeting may be called by 20% of the owners signing a petition. So that's kind of your, as an owner, your, hey, no, really, we want to take this seriously. Now we're moving forward with this because you weren't listening to begin with.
So that would be required. You couldn't get a petition of owners who say, and maybe 50% of the owners say, we want this issue addressed. That doesn't work.
Doesn't work.
You can't do that.
No, I mean, the only things that are open for owners to vote on are what are specifically reserved to owners to vote on, like things like election, or recall, or amending. But they can't just stand up in the middle of an annual meeting and say, I want to fire the management. That is reserved to the board to vote.
Well, they can stand up and say it.
They can say it, but it's not gonna mean anything.
Okay, board standards of conduct under 7/128/401. So as a board member, you have a standard of care that you must adhere to, and that is set forth under this section. 1, you have to act in good faith. You cannot and should not get on the board because you personally want your shed to be approved and nobody else's, right? That wouldn't be acting in good faith. 2, you have to act as a reasonably prudent person would do. Or would act. So if you're out here and the majority of people are saying, well, it wouldn't be reasonable to not pay $10,000 to get a sign when this guy is offering it for $500, if that's the reasonably prudent standard and you're acting against it, that would not be a good faith. And of course, the last thing is acting in the best interest of the association. So you must act in a manner that you will reasonably believe to be in the best interest of the association. Now, how do you do this? One way you can do this is to rely on your experts. Who are your experts? They're anywhere from your legal counsel, your manager, your contractors, etc. So if we come in, if your attorney comes in and says, we recommend you do this, you can say later on, if you're challenged, that you reasonably relied on that legal expertise to form your decisions. Why would you do that? Because it mitigates and minimizes your liability as a director if you are acting under this standard of care. There's a thing called the business judgment rule, and that is if you are acting in good faith, you're acting in reasonably relying on your expert advice. So again, if you have some person who's a little out there coming in and saying something that you know darn well is not going to be reasonable, you vote for it, that's not going to be reasonably acting or prudently acting. So if you have a reasonable person, you're relying on their judgment as an expert in exercising your business judgment, then the courts tend to not go back and second guess that because you are acting in good faith, the association. We get a lot of questions about that because board members worry, like, well, what if I pick the wrong decision? It's like, well, first of all, we generally don't know what the wrong decision is. It's more of a, is it going to be challenged or not? And if it is, and you made that decision attempting to do your best as a board member for the association in the best interest of the association, then you really don't have a lot to worry about. Okay, questions?
Yeah, on the best interest of an association. Like I have an individual who wants to be on the board. He wanted to place with someone, but I told him because he wasn't in the middle of wait to the elections. But we have concerns with the board for this individual just because possibly ways to perform in the past. And when I look at the best interest association, do I as a board could say I don't want to really have him on the ballot? Or do I still have to put him on the ballot because people aren't going to know what we deal with? Where does that apply for the best interest association?
So you would not be able to keep him off the ballot because that would be restricting his rights and the owner's
So I
rights.
put him on there?
Yep, and they would get to decide whether or not to elect him. So you might want to do some groundwork about
Yeah, well, I talked to him
quite
about
frankly, but
caveat of just the interest of it.
yeah, you can't restrict it.
Okay.
The only restrictions are going to be like if you have an owner, if under your documents you have an owner where you're allowed to suspend, let's say, from running for the board because they're behind on assessments, something like that. But you can't just say, no, you can't run. Go ahead.
What if they got voted off in the rerun?
They can. Isn't that a mess? Yeah. So if there's a recall meeting and they get recalled and then suddenly position comes open, they can certainly run again. And sometimes people have short memories, so yeah. We've had a couple of those. All right, now we're moving to federal laws. Chuck Norris once stopped a bank robbery via satellite. I wasn't there, but I heard good things about him. Okay, so satellite dishes. There is a federal law called OTARD, which is terrible, which is the over-the-air reception device rule. Well, it is. I had a friend of mine worked doing federal government contracts and kept talking about OTARD, and I was like, I don't know what's happening, but it turns out it was fine. So the question is, can you ban satellite dishes? And the general answer is no. However, what you can do is you can look at size. So this is going to be under Federal Code Chapter 47. Section 1.4000. It applies to a dish antenna 1 meter or less in diameter, an antenna 1 meter or less in diameter that receives wireless cable, or an antenna for local TV. So conceivably, if someone brings in a 1987 dish that you could float onto outer space, you could probably say, hey, we want a little smaller one, but in general, you can't ban it. The association cannot create rules or restrictions that impair the owner from installing, maintaining, or using the antennas covered by this rule. So you cannot say you can't have them because that's a restriction. You cannot say you have to have a permit prior to installing because that would unreasonably delay it. You can require that the owner notify the association. But again, you can't do it in such a way that it would unreasonably delay it. So if you say no, you have to notify us before you set it up, and that means they have to jump through a number of hoops and it delays installation. That's a restriction. But you can certainly say, if you notify us, but it can't be part of a pre-approval requirement, or any type of cost, increase in the cost of installation. You can set forth your placement preferences, not your placement requirements. Meaning that you can say, hey, we would prefer that you put all of the satellite dishes on the south side of your home. With the caveat being that if I come along and I can't get a normal, regular, good signal from that placement, I can put it somewhere else. There are some exceptions, such as safety restrictions. So for example, if you say you cannot put your satellite dish on the fire escape, that would be okay, because it would be a safety issue, because it's hard to crawl over a satellite in the event of a fire. But you then can't say, well, you can't have your satellite dish, but you can put your saddle out there, that's fine, right? It has to be, if it's something, if it's a rule that says there is a safety issue, you can't pick and choose. If it's all similarly sized, you have to ban all of it. Yep.
How about a shared roof that HOA maintains? Can we keep them off?
So to the extent that you can set forth a preference and they can actually get a valid signal, you could say we prefer that you put it over here. However, if the only place that they can get a signal is on the HOA roof or the HOA maintained roof, then it can go up there. So what you're going to want to do is a maintenance and indemnity agreement that says they're responsible for damage.
Thank you.
Much like you would do with a solar panel. Yep.
So piggybacking on that, somebody wants to put a satellite dish on the roof, which you don't own, the HOA owns. They do the intrusion into the roof, then they move away. And they leave that satellite dish there, and then there's a water leak. Who's responsible for that then? I mean, the owner who did it is gone, and the new owner says, I didn't put it there, and what do you do?
So it's gonna depend. If there's nothing, then you can conceivably, I suppose, tell new owner they're responsible because now they own the property. But if I'm new owner, I'm gonna say, I ain't paying it, I didn't do it. So the better option is to get out ahead of it and say, here's our, satellite policy, is that if it's on a common element, we're going to do a maintenance and indemnity provision that states that you're responsible for any damage to the roof and it must be removed when you move. Same with solar panels. So solar panels, you have to allow, you can set forth a preference in a policy, but what you can't do is set forth any type of requirement that unreasonably delays or that increases the cost of installation by more than 10%. So on the solar panels, a lot of those will go on common element roofs maintained by the association. You're going to want some type of maintenance and indemnity agreement that says who's responsible if the roof starts leaking. Okay. Well, that was satellite dishes. Did you guys like that one? Okay. So if you weren't with me already, now we're going to do bankruptcy. This is one of my favorite topics. If this is not one of yours, then this is going to really go rough for you. So with bankruptcy, there are a lot of different chapters of bankruptcy. But we're not going to talk about all of those because Melissa took up all the time with Kiowa. But it is a big statute on the strangle. That guy over there. I know, that guy asked me questions. So there's chapter 7, chapters 11, chapter 9, chapter 13, blah, 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 blah. The ones that we mainly see come through for the association that I'm going to talk about today are going to be 7s and 13s. Those are the ones the owners are going to file most of the time. Every once in a while you get an owner who is a business that is going to file a Chapter 11. Certainly some of you may have, what was the one that just, there was a big, was it solar that filed bankruptcy that affected a number of our associations. We had some oil operations that did it. That's a different type of bankruptcy altogether, and that's more of a plain restructuring. Chapter 7 and Chapter 11, that's going to affect your lien and your right to collect personally from the owner. What I mean by personally is, I mean garnishing. You can always collect on the lien, basically. All right, so Chapter 7, that's kind of your down and dirty bankruptcy. It's usually 3 to 4 months, maybe 6 months. It tends to be filed by people who either are under what is called the means test, so they make under a certain amount of income for their household size in order to file a Chapter 7, and it's people who aren't necessarily trying to save a secured asset. So like a house or a car. Chapter 7, sometimes people don't make enough or make little enough that they can file a Chapter 7. And if they're caught up on their mortgage or their association, it's fine, it doesn't matter. They're gonna get a discharge, which is the court order saying they don't have to pay garden variety debts. That's gonna be your unsecured debts, so your medical debts, your credit cards, things like that. With the association, we have what is called a secured debt by the nature of our CC&Rs, our declaration. And so what that means is that we have a lien on the property. Now, with the association, we actually have a pretty powerful lien. It's called a super lien. Unfortunately, not the entire lien. It's only 6 months worth of assessments that's super lien. Why does that matter? Because when we start to get into fights over how much equity is in the property, 6 months of our assessments are gonna trump a mortgage. The rest of it is all gonna go down below it. Why does that matter? Because later on when we get to Chapter 13s in a minute, we'll talk about adversaries, so keep that in mind. So Chapter 7, if I file bankruptcy, I'm the owner, I say, great, I file bankruptcy, I'm keeping my house. The association cannot sue me personally, meaning they can't sue me in county court, let's say, for the $5,000 that I owe the association. That portion must be written off as to my personal responsibility, meaning you can't bring a lawsuit, you can't get judgment against me for that, you can't garnish me, you can't force me into some type of payment plan, etc. However, what you can do is it does not extinguish the association's lien. So while you have to write off that balance, late fees, and interest as to me on the ledger, you're going to put a little note to yourself that shows how much was written off for the lien, because the whole balance on the lien can be collected either through a foreclosure or later through the sale of the property. We get a lot of questions about this from owners who say, I filed bankruptcy, I shouldn't have to pay this from the proceeds from the sale of the house. It's a completely different animal because it's a lien. Chapter 13s are going to work in much the same way as a Chapter 7 insofar as there is a pre-bankruptcy debt which discharges, and then there's everything I owe after the bankruptcy. But a Chapter 13 is going to be a repayment plan, a reorganization. A Chapter 13 will run anywhere from 3 years up to 5 years, and it will provide, with some rules, that the association can be repaid over time and still receive future post-bankruptcy filing assessments. Here's how. When a debtor files a Chapter 13 bankruptcy, there's going to be what's called a proof of claim deadline. That deadline is going to be roughly 72 days from the date it's filed. In order to be paid through the bankruptcy, you have to file a claim. If you do not file a claim, you're not getting paid through the bankruptcy. The second thing you have to do once you file that claim is look at what the plan is. There's a Chapter 13 plan. The plan just says, here's what I owe and here's how I'm repaying it. If the association is not in the plan or is in the plan for the wrong amount and the court approves that plan, the association is stuck with whatever that plan says. Your lien will still survive the bankruptcy unless the debtor tries to get rid of the lien, get there in a minute. But if you do not object to the plan and you don't file a proof of claim, you're not getting any money for theoretically up to 5 years unless that case gets dismissed sooner. And if you do get money and you didn't make sure it was properly included in the plan, you might be only getting a third of what you were owed. The same thing happens though when the bankruptcy is discharged. If there's personal liability because you didn't file a claim or you didn't object to the plan to get the correct amount in there, then you may not be able to go after the debtor. You still have that lien. So you could still foreclose, you could still collect from the sale. Here's the big exception. In a Chapter 13, the debtor can do what is called an adversary. It's a fancy word for lawsuit within the bankruptcy. If the debtor brings an adversary to void or strip off the association's lien, and you get that paperwork, you need to get it to the attorney, because if that lien gets stripped off, you're only gonna get the 6 months worth of assessments. That's super lien. So the takeaway here is if you see a bankruptcy, phone a friend. Okay? Phone a friend. All right?
How do they see that? Is a notice sent to the?
Yes. So what they should be doing when the debtor files bankruptcy is they will list all of their creditors, which will include the association or the association's attorney or the management company, or I've seen it where the association used a collection agency. But if you're on there and you have notice and you don't file a claim, that's where we have an issue. Now, of course, if you were never listed to begin with, we can always file a motion with the court saying, hey, court, we want to be in bankruptcy, we weren't listed, we didn't know. But for the most part, that's how you would find out. Yes?
The super lien covers 6 months, up to 6 months of assessments. Does that include a special assessment?
It does, but it does not include late fees, interest, legal fees, and costs.
So a special assessment.
If it occurred in the 6 months prior to the notice of election and demand and a foreclosure, that's where that 6 month comes from. So let's say there's no foreclosure filed yet, we use the date it was requested. Okay? All right, I know, now I'm throwing in foreclosures, good lord, we're never gonna get out of here. All right, now I'm gonna turn it back over to Melissa, who, if you remember correctly, did try to escape earlier.
I did, I won't try it again. So I'm gonna, there's a lot of slides in the Fair Housing Act, but a lot of it is really just for you to review on your own, because there's some of the criteria that would apply to the scenario I would bring up. But essentially with fair housing, all we're talking about is an association's inability to discriminate against certain protected categories. These are the two laws that apply, the Federal Fair Housing Act as well as the Colorado Civil Rights Act. You can look up any of either of those on our website. But these categories here are all the ways you might be able to discriminate. You don't even know it if you're discriminating. Many times you don't know you're discriminating against a particular person under what category. But these are all the categories that you could conceivably discriminate against a particular homeowner or a resident. The one I want to talk about today is really handicap disability and handicap special or slash disability. Because the issue that usually comes up are emotional support animals. I mean, that is like so popular, so I'll talk about that here in a second. But essentially, associations cannot discriminate against any of these categories. And there's a lot of material on our website that discusses all the other ones as well. But let's talk about handicaps and disabled persons. So, you cannot discriminate against a person with a disability. And one way to discriminate against a person with a disability is to fail to allow them to have a reasonable accommodation. That's one way to do it. What that means is, if a disabled person needs you to not enforce a particular rule or regulation against them, in order for them to enjoy equal use and enjoyment of the community, then you can't enforce that rule against them. So for example, if a blind person needs a seeing eye dog, and you have a rule that says no dogs, no pets, you can't enforce that rule against that person because they need the seeing eye dog to give them equal use and enjoyment of the community. That is what's called a reasonable accommodation. And here's what the definition of a disability is. After this class, I'm going to give probably to Betsy a wonderful article or a statement from HUD and the Department of Justice that they put together an FAQ on reasonable accommodations, because there's a lot of questions that come up. So you have to prove the person has to show they're disabled. There's there's a vast range of disabilities. This is in that joint HUD statement. It's all there, so you can take a look at it, but I did want to point out that one in the parentheses. So a person, thank you. Drug addiction is a disability other than addiction, I should say, caused by current illegal use of a controlled substance. So if they're recovering, then it's a disability. But if they're still using, it's not. But look at all those vast range of disabilities. Those are all potential disabilities. Now, when it comes to, I already talked about this, definition of reasonable accommodation, it's really just failure to enforce, or you cannot enforce a particular rule, regulation, practice, restriction against a disabled person in order to allow them to use the property equally with everyone else. And the accommodation itself that they're requesting must be related to the disability. So if somebody is in a wheelchair and they say, I need a dog. Okay, they're in a wheelchair, that's a mobile disability. They say, I need a dog, and you have a no dog rule. How is that dog needed for their disability? So it has to have some kind of nexus. There might be a reason, they might need the dog to pull the wheelchair. I mean, I've seen that happen, but it has to be connected. So the accommodation must be related to disability. Also, the accommodation must be reasonable. So in a later section here, we talk about what if they need a dog and that dog is biting everybody or biting other dogs. That's not reasonable. Or let's say they live in a condominium community and they want to keep a giraffe in their condominium unit. That's not reasonable. So it has to be a reasonable accommodation as well. So here's the issue. Oh, I love that. That is so true. Emotional support. My emotional support animal is coffee. I need that every single morning. So the thing that seems to be the big topic today with disabilities and reasonable accommodation is the emotional support animal. That is when they need an animal, and sometimes it's a dog, sometimes it's a chicken, sometimes it's a cat, a miniature horse, whatever, in order to have equal use and enjoyment of the community. So if you have, somebody says no pets, and they need an animal, and they're disabled, then you have to allow them to have that animal. So how do you know that they're disabled? Okay, so you cannot ask them for verification of their disability unless it's not apparent. Seeing eye dog for a blind person, usually it's apparent. Somebody has PTSD, might not be apparent, and that's a disability. So when you're faced with a request for a reasonable accommodation, you have to, if it's obvious that they need it, let's say a person in a wheelchair needs a ramp, that's obvious to get in their house, you cannot deny it. You cannot ask for verification. If it's not obvious, you can ask for verification. And the verification itself, when I send you this article from the DOJ and HUD, it tells you different ways that you can verify that, but it doesn't have to be a doctor. It could be a social worker, it could be some kind of professional healthcare professional. So there's a lot of ways that they can verify it, but you can only ask for verification if it's not obvious.
And do they actually cite what the?
It gives you some examples. So also it's any animal. So the next slide talks about ADA, it's only dogs and miniature horses. With ESAs, it's any animal. And no, they don't have to have some kind of certification saying that we are disabled or the dog is trained in any way, not at all. They just have to say they're disabled and they need that accommodation in order to have equal use and enjoyment. And animals, emotional support animals are not pets. So if you say you have a rule that says no pets, they're not pets. They're not considered pets. So don't put them in that rule. So I just want to go through some FAQs. We've got a lot of information on there as well about ESAs on our website. What if the ESA is a pit bull? Still have to allow it. Now, if that pit bull or that chihuahua starts showing, just vicious behavior, then it becomes unreasonable. What if they want 2 pets and there's a 1 pet per unit cat? They're not pets, so don't count them in that cat. What if the animal causes damage injury? Then the damage, the homeowner has to pay for it. And if it continues to cause damage, then it just becomes an unreasonable request. Same with injury. Causes injury, unreasonable request. Does ESA have to have some kind of certification? No. Can I require a person to get insurance for ESA? No. Can I charge a pet fee or deposit for that ESA? No. Can ESA be temporary? Yes, if the disability is temporary. But you can't be asking them to reapply and re-verify every week. Maybe a year goes by, and if they had some kind of temporary injury that has them in a wheelchair for a year, you can request them to resubmit. But it can be temporary. I can keep the ESA out of the pool area, right? Wrong. They are allowed in all the common elements. The only area in the pool area that they're not allowed is in the pool itself. That's more of a health safety issue. Okay. So I went through that really quickly because there's a lot, and I will open up some questions later, and we've got a lot more to go through. But some of the things you just really want to keep out of trouble is if you have these requests of ESAs or any kind of accommodation for disability, get a policy in place. Make sure your rules, regulations, and language aren't contrary to the statute. Talk to your attorney. Make sure you're treating everybody the same, which is why you want a policy that tells you how to treat everybody. Make sure that if somebody is requesting the ESA, you respond quickly. What they like to see is quick response and dialogue, and always be professional. I know that there's some people that are trying to cheat you by saying that they're disabled. Try to be as professional as possible or you're gonna be in the news. Okay, other discrimination issues really quick. You could discriminate against families with children. You can't have something that says no one under the age of 18 in the swimming area, because that's discriminating against families with children. If you say no one under the age of 12, that's okay, because the issue is a safety issue, not a teenagers or crappy, people. Yeah, real quick. We'll get to that. Holiday lights may be installed from December 1st through December 31st only. That's a religion that you are preferring, right? Christmas. No playing on the common area. Only kids play. Family with children. So that's a no-no. No group homes. That could be against disabled persons who live together in a group. So if you have any of these rules, make sure you talk to your attorney about the rules, and maybe they're valid, maybe not, but you really need to ensure that by speaking with the attorney. ADA, the only thing I wanted to say, because a lot of people always bring up ADA, the American with Disabilities Act is only applicable to places of public accommodation. That means your common elements are open to the public. Most associations don't open their common elements, their pools and facilities to the general public. It's only open to the homeowners, the residents, and their guests. So chances are the ADA does not apply to you. If it does, then speak with your attorney. But with ADA animals, it's the same kind of thing, that you have to allow disabled people under the ADA Act to have animals that are trained, and there's all these different things that are applicable to the disability animals, but it's only dogs and miniature ponies. So it's very different. There's a whole article on our website about the difference between ADA and Fair Housing Act, but ADA probably doesn't apply to your association. Look to the FHA for those disability requirements. Okay, somebody mentioned HOPA, the 50, I didn't say. Okay, HOPA is the age-restricted community, 55 and over, right? There's a federal law called the Housing for Older Persons Act, HOPA, which essentially allows communities that qualify to discriminate against families with children. They can say no one under the age of blah can live in this community. There's a lot of requirements to be a HOPA community, but here are the main ones. At least 80% of the units in the community must have a person 55 or over living in that unit. It's not 80% have to have some person 55 or over owning the unit. They have to have somebody living in that unit that's at least 55 or over. The 20% is that buffer. So 20% can allow others to live in there. The other thing that you have to do to keep your HOPA qualification is publish and adhere to policies and procedures demonstrating the intent to be a HOPA community. There should be newsletters. There should be a sign that says this is a 55 and over community. There should be something showing that you're trying to continue to be a 55 and over community. And finally, you have to comply with HUD regulations on age verifications, which means every 2 years, at least every 2 years, you have to verify that 80% rule is still valid. There's a lot more in there, and there's a lot of exceptions and some limitations, but that's HOPA, and we have a great FAQ on our website that discusses all the other questions about HOPA.
All right, governing documents, much like Maslow's hierarchy of needs, this is the hierarchy of governing documents. Your law, that's going to be at the top. Your rules, guidelines, policies, resolutions at the bottom. Now, the key is that if you have a rule that conflicts with the law, you have to change it. That's the thing to remember here, okay? Some of your documents you'll see in the declaration, it'll say something like, if this anything in the declaration conflicts with anything in the bylaws, and the bylaws control, or the declaration controls, or something like that. However, if they're silent, this is what you're looking at. Okay? I'll take it. I get all that. It's being recorded. It's being recorded. Declaration, they're going to be specific. The declaration runs with the land. What does that mean? If I sell my house, the new person's subject to the declaration as well. I don't get to just say, no, you're fine. It goes with me. It is going to create rights and responsibilities. It is going to set forth the board's authorities, such as the board has the authority to make rules and regulations. It's going to talk about maintenance and insurance obligations. If your declaration is a mess, or it's very confusing, or you need to clarify something, then we'll need to amend it specifically about these maintenance and insurance provisions, but we'll get to that in a minute. So it's going to set forth those obligations. It's going to talk about assessments. Please make sure it talks about assessments. Please don't let us sue somebody and then it turns out that you have no authority to sue. We should double check it too. But check, because if you're charging assessments and you don't have a declaration that allows you to charge assessments, we have a problem. It's going to have use restrictions. What is a use restriction? Nobody really knows because it hasn't been defined by the court, but generally speaking, it's going to talk about what you can and can't do in your home. What does that mean? You cannot have short-term rental restrictions unless it's specifically in your document, your declaration. You cannot say no one's allowed to smoke in their home anymore unless that's specifically in your declaration. Those are all usage requirements. Pets. If your declaration says you can have one dog and you decide that we're not going to have any dogs, that's a usage restriction and you can't do it. You would have to amend the declaration.
Amanda, I know you're on a roll, I'm sorry. The covenant say you can have household pets, and they make a policy saying that chickens or fowl are not pets.
We'll talk about that in the rules and regs section.
Thank you.
Coming up.
Yeah.
Jumping ahead.
Yeah.
It's also going to talk about architectural review or design review committees. Now, be careful with that one, and I know I'm moving ahead on the slide. If you have a policy that says everything needs to go through your architectural committee, and then in your declaration you don't have any reference to an architectural committee, it says the board makes those decisions, you're going to make sure that your policies reflects that. Likewise, it might say design review committee. So don't say you have to submit it to the ARC when it's really a DRC. I know it sounds like semantics, but it matters if we go to court as a challenge later on. So let's talk about amending declarations. So you can do a couple amendments. You can do limited amendments. That's where you only are amending one or more individual provisions, or you can do a full amendment and restatement of the declaration. It is usually more efficient and less costly overall to do an amendment and restatement of a declaration if you have a number of provisions that are either illegal or not compliant with the law or simply do not reflect where you're at with the community. However, if you try to do an amendment and restatement, or if you try to do more than one limited amendment, you need to be careful because if it's all on the same ballot that we talked about earlier and an owner says, well, I don't like this one and votes no on all of them, well, now you've wasted all kinds of time and money. So when it comes to these amendments in general, you're going to want to canvass your community, you're going to want to have meetings, you're going to want to do all of this before you contact your attorney to draft the amendment, because otherwise it's just going to be a waste of money and it won't pass. So what do you need to amend the declaration? No less than majority, so 51%, but no more than 67%. So that's going to be your cap. Now, check your declaration when you go to do these amendments because they will often have mortgage requirements or notice requirements, and sometimes insurance notice requirements. And there's going to be different provisions in there. So it might say that you have to notify a mortgage if you're doing any of X, Y, and Z amendments. It might say you have to notify the mortgage if you're doing any amendments. Or it might say you only have to notify those mortgages who have submitted a written request for notice. Sometimes they're called eligible mortgagees. Same with the insurance. It might say you just have to notify insurers. It might not say anything about insurers. But this is all stuff we need to pay attention to when we're doing the amendments. You do have the option, I don't think I would do this with a limited amendment, with an amended and restated declaration, you can go through what's called the court petition process. So let's say you had 50% of your owners who voted yes, but it wasn't enough to pass it. You could petition the court. It's costly, it's time consuming, it's expensive, but you can petition the court and get a court ordering the amendment as well. I won't get into too much more on that because it's kind of a big deal.
Do you have to register an amendment that you approve with the county where your original documents are?
Yep, so once it's approved and certified, the certification, your document will say something like 67% membership approval, and then the secretary has to certify it. So once all of that's done and approved, then it would be sent in to be recorded, so it's part of your declaration. Because remember earlier when we talked about declarations and how if they're not recorded, we have a big problem. Same goes with the amendments to the declaration. Oprah governance has approved, and you get an approval, and you get an approval, and you get an approval. But there's no cars. I mean, we are nonprofits after all. Okay, so your articles of incorporation, they're your birth certificate for the association. I don't know about you guys, but if you ever sit in bed and your brain goes, you still awake, where's your birth certificate? You freak out. You think, well, why am I thinking about that right now? I don't know where it is either. So, articles of incorporation, they are filed with the Secretary of State. That is what creates your nonprofit corporation. Every once in a while, you might have a problem where you have your articles of incorporation that created a corporation, and yet you don't have a declaration that created an association. If that happens to you, call your attorney, please. So the articles of corporation that's going to create the nonprofit, it's going to set forth the general purposes and powers of the business. It's going to speak to the initial board and number of directors. It's going to talk about your limited liability provisions and how to dissolve the corporation in the event that you need to. We're getting that question a lot these days because our associations are frantically worried about insurance and paying for things, and they say, well, what happens? Can we dissolve, etc.? You can. There's a lot to it though, and of course it costs money because everything does. So it's in there though, it's in the articles. And of course I like this cartoon which talks about if you're going to be on the board, wear this paper bag so nobody recognizes you. All right, so if you were going to amend the articles, for the most part you have to have owner approval to amend them. There are some exceptions. So the board can amend the articles to delete the names and addresses of the original incorporators or initial directors. So some of you, if you have a document from 1985 and it'll say Joe Smith was a director, you can amend that to get that out of there and change it. You could certainly delete or amend your registered agent. For example, if you change management companies and you have to, we've talked about main place of business, so you need to update your primary place of business, the board can do that. And then if you fail to register with the Secretary of State and your corporation goes defunct and you need to reinstate it, because of course you've registered now with DORA, because we talked about that earlier. So if your corporation is defunct and you need to reinstate it and the board needs to do a one or more entity change, you can do that as a board. However, if it comes to anything else in those articles, you need membership approval. Okay, yes?
What if you now have a management company and the board, there's not a constant board person for umpteen years, what do you use as an address when you're registering?
Yeah, that's a good question. So you can, a lot of times what we see is like the board president will register with their address. I don't know if you've seen different things for the
For self-managed.
Yeah.
Yeah, it's, you have to pick somebody on the board. It should, or if you don't have a management company, somebody on the board, it's just.
Sometimes you see the
Can you do a
secretary.
PO box or something?
Not for registration, because they need to serve you.
So the Secretary of State, you have to actually put a physical address in, because if you are ever served with a lawsuit, it has to have a place to physically serve you.
So then we have two steps.
Right, unless somebody carries over on the board. Okay, so your bylaws, that's gonna be your operational manual of the association. That's going to set forth your governance procedures. It's going to talk about what you can and can't do as a board. The membership requirements, your meeting requirements, it'll have notice in there. And remember that the statute says 10 to 50 days, but it might say things like you have to have your first meeting of the board of directors within 10 days after your annual meeting where they're all elected. That's all going to be in there. It's going to talk about voting rights. It's also going to talk about elections of board members, the board terms, staggered terms. Of course, we have the nonprofit default, but most of the time the bylaws are going to set forth that information. It is also going to have occasionally such things as if you're going to notice the members, it has to be via registered or certified mail. That's a big deal when it comes to, like down the road, we get into these policies where you have to send out notices. If you have a provision like that, I would recommend removing it through an amendment, but you do what it is you want to do. Bylaws are also going to talk about quorum, and then they're going to talk about the action without a meeting provision if it's in there. Of course, if it's not, you now know that there's that default under the nonprofit code because you've been paying rapt attention. All right, so amending the bylaws, it's the classic answer that everybody hates, which is, well, it depends. So if it's pre-Kiowa, the board can amend the bylaws on its own, just via the board, except for quorum. If you're going to raise or lower your quorum requirement, you have to have membership approval. If you are post-Kiowa, you cannot amend the powers and duties of the board, the terms and qualifications of the directors, but no quorum. So you can't do any of that if you're post-Kiowa. You cannot say the board now has the power to move into your house and live there. You can't do that. That would be bad. You cannot say we're now going to make this that every board member can serve 10 years. You would have to have the membership vote for that. And then, of course, the exception to these is if the bylaws specifically state the board cannot amend. Okay.
Yeah, I know it's 8 o'clock, and I swear we're gonna be just a few more minutes, so I'm gonna run through these really quickly, and then we'll open it up for questions to anybody who still wants to stay for questions. We'll talk about rules, regs, ARC guidelines, and policies. The difference, really, rules are just statements of behavior, violation of which will cause a penalty like a fine. ARC guidelines are just rules related to construction provisions. Policies are courses of action. And then resolutions, all that means is the board is formally resolving to take action. So when you say resolution to do something, it just means the board formally resolves to do something. And what can you do for rules and regulations? Somebody had mentioned, I think, that for rules and regulations, can you clarify something? Yes, rules and regulations are intended to clarify and supplement what's already in your covenants. So if you have something like commercial vehicle, you can define that in the rules. What does screen from view mean? Does that mean from completely naked from the naked eye or screened with landscaping? How long is a short-term rental? All of these are defined terms that you can define in your rules and regs. Household pet, you can say dog, cat, whatever. We always talk about vegetable garden. What exactly is a vegetable garden? Or what exactly is a tomato? So just recognize that when you have rules and regulations, if you're going to define them, that's great. The board can do that, but another board can always overturn them. So if you want it to stick, amend your declaration and put it in the declaration. Only owners can then overturn it. You can't add use restrictions over the units. Is this me? This is me. Okay. You can't add use restrictions over units or lots because those are use restrictions. So you can't add new rules, but you can add rules over the common elements. You have complete authority to say what can and cannot be done over the common elements. If we're just talking about inside the unit, that's a use restriction, has to be in the declaration. When to adopt them? When you want to clarify something, when you want to, define an ambiguous term. Board usually adopts them. Can't do that in executive session. That was in a prior slide. And make sure you consult your adoption of rules, regs, and policies policy, which Amanda's going to talk about because it's a policy that tells you how to adopt rules and regs. Sometimes the owners are required to approve them, but that's rare. And remember, they're at the bottom of that chart that we have in the prior slide, which means rules and regs can't be contrary to anything above them in that chart, that pyramid. Architectural guidelines are just rules that address construction improvements. So that's what we just talked about. And they're also at the bottom of the hierarchy. The two areas where I find problems are when you're adding new criteria for the review, because the review when you're reviewing a submission, it's usually for aesthetics or harmony or something like that, but it's stated in the declaration what your criteria for review is. You cannot add something new like view, which is what I see a lot of people say. Oh, it blocks somebody's view. Can't add it if it's not in the declaration. You can clarify aesthetics, process, all of that. Who adopts? Usually it's not usually. It's document specific. So sometimes it's the Architectural Review Committee that adopts them. Sometimes it's the board. Sometimes it's the ARC that recommends them to the board. So look at your documents to see what those requirements are. And again, they're at the bottom of the hierarchy.
All right, policies. Policies are established by the board. They also cannot conflict with the law. They cannot conflict with anything in the 3 documents. They cannot create requirements that you don't have general authority for. So again, using that short-term rental example, you cannot say we now have a policy against short-term rentals. You have to put it in your amendment because it's a usage requirement, in your declaration for usage requirement. They cannot be more restrictive than what is already in your documents. Here's the exception. If your documents are old and outdated and not compliant with Colorado law, then you may have a policy that conflicts with the declaration, but that's okay because it lines up with statute, okay? All right. They may not create exceptions, and you cannot add board powers. These are just fun little cartoons. I'll let you read them later. Or you can read them now, whatever. So what they can do, they're much like rules. They can define or clarify ambiguous terms that are already in the documents. They can develop or add a process to accomplish something already allowed in the documents. We say in the documents, but remember by law as well, because let's talk about xeriscaping. If your document says no xeriscaping, we now know the law says you have to allow xeriscaping in certain situations. So you can develop a policy that says, hey, this is our xeriscaping policy or electric vehicle. However, to the extent that it's allowable under law and it's already allowed in your documents, then certainly you can add a process. So think of your, I don't know, architectural review policy or something like that. You can have a policy that governs the use of common elements and sets forth expectations of conduct on common elements. So while you cannot have a policy that says no smoking in your unit without a declaration amendment, you could have a policy that says no smoking on common elements because the association owns the common elements. There are a number of policies that are recommended, but there are 9 that are actually required by law. These are set forth here. The first one is adoption of policies policy. I think that's a silly name, but that's what we call it. And that's going to set forth how you actually go through, notify your membership when the board does adopt a policy. It's going to be based on your governing documents, or it should be based on your governing documents. Because some of your governing documents are going to say that you have to have, you have to notify all owners ahead of time. Some say afterwards. So it's just going to depend. Alternative dispute resolution. If an owner has an issue with the association that is not a collection issue, this is going to set forth how to resolve it before going to court. That is what ADR is. It's resolving through, it's very similar to like a mediation. Conflict of interest policy, that's going to be what happens when a board member has a conflict of interest and how to disclose it. So if I want you to hire my brother because he's the best contractor in the world, this policy is going to tell you what I would have to do in order to tell you about it and excuse myself from voting, etc. Conduct of meetings is how to run the meetings, including membership meetings as well as board meetings. Inspection of records, Melissa talked about earlier, that's going to be what you have to turn over, what you may turn over, and what is not required to be turned over upon request. It's also going to set forth a policy for the owner. When they say, I want these documents, you can say, you can have the documents that are specified by law in our policy, and here's how you do it. Collection policy under HB 1137, which is House Bill 1137 passed last year. That's that now revised policy. You always had to have the collection, but now it has to have specific language in it about turnover, notice requirements, posting, etc. I could probably spend an hour on that, and I won't. Covenant enforcement is the same way. You've always had to have that policy, but now under the House Bill 1137 that changed that, there are requirements. For example, you cannot fine an owner more than $500 total for an offense. You could do 200, 300, you could do 50 a number of times, whatever, but it's 500 total. You have to give 2 60-day cure periods. So if my camper is in my driveway and you don't like it, you could send me as many courtesy notices as you want to, but under the law, you have to send me a 30-day cure before you can fine me, giving me 30 days to pull my camper in. And then if I don't, you can fine me and send me another 30-day notice. It kind of has really eliminated the repeat violations issue, and we thought there might be a cleanup bill this year on this, but there has not been on collection and covenant. The last 2 are going to be about your reserves. If you don't have a reserve and you don't know what I'm talking about, we should probably talk about that. But investment of reserves is going to set forth how your reserves are invested. So it is very applicably named. Boy, I couldn't skip that out. And then the reserve study. Usually we'll say the reserve study is conducted every 3 to 5 years. Okay? All right, now of course, as we talked about earlier, if there is a procedure or policy that your association is doing, which happens sometimes, and yet you don't have that set forth, or you have a completely different procedure set forth, you should revise your policy. So if your policy used to be that you cannot have wood fences, and the declaration
doesn't prohibit whatever. And now you say, well, owners are allowed to have all of these, revise your policy so that it reflects what you're doing right now. With the exception, again, that if what you're trying to do is not allowed by your declaration, then you're gonna need to amend the declaration or the bylaws first before you do the policy. Okay? All right. We're almost there. This is my we had a successful meeting slide. Okay, this will take me 2 minutes. Drafting techniques. Make sure that when you're adopting any amendments to the rules and regs, that they're complying with state law and federal law. We just talked about that. Talk to your attorney. Scratch that. Talk to Altitude Community Law. That's who your attorney is. Are you establishing enforcement standards that cannot be met? Do not put something in the documents that you're not going to be able to enforce or you don't want to enforce. Don't put something in there that says you can only park somewhere for 2 hours if you're not going to hire a parking company to check that, because you could be exposing yourself to liability for failure to enforce. Are you basing your amendments on outdated notions? Don't think about the 70s color palette with the whatever, we're in a different time now, and think about what people want today. And we're under a generation, 4 different generations are living in the same community now that own houses. So just be cognizant about that. Don't target a particular group, especially a protected category, but even if it's not a protected category, renters versus owners. If it's not in your declaration, don't say, if it says you can have 2 dogs, don't just say only owners can have 2 dogs. That better be stated in your declaration that only owners, because then otherwise it's applicable to everyone. Are your provisions too specific or not specific enough? We just talked about that, which is you don't want to be too specific if it limits what you want to regulate. If you do want to be very specific because you don't want any future board to overturn that, then make sure it's in the declaration amendment so that your 2 pet cap will stick and future boards can't overturn it. Okay, that's it. Thank you so much.